The court is going to start today's proceedings. We apologize for this delay. 30 minutes delay was not, we were here since 7:30, but we were told that some attorneys and some defendants were not here yet. I don't know why, but we had requested, the last time we had requested everybody to be on time. So we don't have to sanction anybody. Based on the report by the registrar, all defendants except RUSESABAGINA and his counsel are here. The party seeking compensation are represented, and those who were representing themselves are not here, but they were notified, and the prosecution is represented by the usual team. RUSESABAGINA did not show up today. So there's a report by the jail where he's detained saying that he was not going to be here today. So I request the registrar to read that report. Then we will proceed. Honorable President of the High Court of the Criminal, the cross-border crimes and international crimes. This is a report about RUSESABAGINA Paul, who has refused to show up at the court today. Your Honor, based on the notice of 12 March 2021 requesting RUSESABAGINA Paul and his co-defendants to come to court today, 24th March 2021, we are informing you that Mr. RUSESABAGINA Paul declined to be at the court, to appear at the court on his own, from his own will. He told the Nyarugenge jail that he told the court that he will never again appear before this court. He said this, also saying that even apart from today, whenever he will be summoned to appear before this court, he will not come, he will not show up, because he does not expect any justice from here. You will have an annex of the letter notifying him to come to court today. Michelle Kamugisha, CSP, Director of Nyarugenge Prison. That's the report from Nyarugenge Prison. As you may remember, last time RUSESABAGINA had requested about 6 months, saying that he and his counsel needed more time to prepare for the trial, and the court decided that time was not necessary. He was present, he signed for today's court appearance, court proceedings. The court invited him officially, but as you have heard yourselves from this report from Nyarugenge Prison, he says he will not appear before this court. Now, we want to ask the prosecution to give their reaction on RUSESABAGINA's that development from RUSESABAGINA, and then the court will make its ruling. The prosecution, go ahead. And if any defendant wants to react, we will give him the floor. think you were copied. You have that report, right? Your Honor, honorable judges, as the court just informed the gathering, we, the prosecution, have seen that document. One of the defendants, Paul RUSESABAGINA, has refused to appear before this court, even though he knows today's proceedings. So as the prosecution, we know that he was notified, he signed on the document inviting him to these proceedings, and we believe that we've followed all the laws, so the proceedings should carry on. It's the defendant's right to choose to not appear before a court, but the laws provide for such situations. But for us, there's no reason to stop the proceedings. Thank you. Thank you, Your Honor. As the Deputy Prosecutor General just said, it's the right of any defendant to appear or not appear before a court. It's constitutional. When the defendant decides to use their right to be absent when they've been notified, it's their right. He can choose to do so. But we also know the law provides for such a situation. In Article 56 of the law about civil cases and commercial cases and labor cases and administrative cases, when the defendant does not appear with no reason, the prosecution can request that the trial be postponed or that be tried in absentia. Your Honor, we believe that since the law provides for such cases and the same law governs the trials in similar cases, we believe that that law can be applied in this case. And we want to tell the court that such a development of such a behavior by a defendant in a criminal case, a defendant who chooses to not appear before the court when they've been notified, this is not the first time this is happening, whether in Rwandan courts or in international courts. And we know that whenever such a situation occurred, the court decided to proceed with a trial, and the trial would be done in absentia because the defendant was notified but decided to not attend. We can give you two examples. You know the case that was tried by this high court, this chamber on cross-border crimes and international crimes. The prosecution versus Mugesera Leon. In trial number, please bear with us. We'll find the exact reference to that case. I can't find the number right away, but I promise to give you the case number before the end of these proceedings today. In that case, the defendant decided to use his right to decide to not appear before the court for as long as he wanted, until he decided to come back to court. So he enjoyed all his rights for as long as he had been notified. And with international courts or trials, we'll give an example by a case tried by ICTR. The prosecution versus Ferdinand Nahimana, Jean Bosco Baragwiza, and Hassan Geze. Case ICTR /99/52/T, in which case one of the defendants, Jean Bosco Baragwiza, decided to not appear before that court in his case. Then that tribunal ruled to proceed, and they proceeded as if the defendant were present, even though he appealed. This was one of the reasons to appeal. He said he had been denied his right to be tried while being present. And that's a case that was tried by the appeals chamber. Number ICTR /99/52/A, where the case tried that his reason to appeal was not valid because he had decided to not appear before the court during his case, even though he had been notified. So he was not denied his rights. And what the court had done to proceed with the trial was legal. Your Honor, based on these reasons, this report from Nyarugenge prison, and which comes following what Paul RUSESABAGINA had told the court, that he would never come back to this case, to this trial. He has been notified legally, so he is the one who decided to remove himself from this case. So we request the court to proceed with this case, with this trial, and to be tried as if the defendant were present, because he has been notified based on the law and all decisions by the court. Thank you. Are there any co-accused who wants to react? Then Maître Rugeyo Jean, go ahead. Please step forward and use the microphone.
Murakoze nyakubahwa perezida wa nyakubahwa mucamanza kumva ijambo. Nk'uko urukiko rwari rumaze gusomera ababuranyi bose raporo yakozwe n'ubuyobozi bwa gereza ku bijyanye no kutitabira kumwe mu baburanyi.
The accused who didn't come to this hearing, we would like to present to the court what is based in Article 57, which states that factors around those who would not appear in court, such as the case that we have today, given that the case has many accused who are here, because this case has more than one person who is accused, and they're all connected, and some have come and some haven't come to this hearing, as the prosecution just stated, based on Article 57 SPCA. Also on Article 57, it is expressed on what happens when some appear in court and others do not appear in court. Yet they are being accused of similar acts which are interconnected. We are here to say that the proceedings should carry on, especially when it has been stated that some of the accused and their representatives are also asking that the court proceeds, though there is connectivity in all their cases. Despite the fact that some have come to this hearing and others haven't come to the hearing, the court can adjourn this hearing, or the proceedings can carry on in their absence. Therefore, on behalf of the accused that I'm representing, basing on this article, we are asking that this proceeding will carry on, irrespective of the absence of the accused who didn't come to this hearing, yet they had been notified, they had signed for that, but following the report of prison, you have understood that they will not appear in this hearing and even in the upcoming hearings. So following the law of such cases, we are asking that we follow the law, even as we pay attention to the fact that there are no other laws prohibiting such a hearing. So I would like to ask, is there any article from the law of such criminal acts, the law dealing with such criminal acts, if anything can be done when accused persons choose not to show up in court? Thank you, President of the Court. But if there is an accused who doesn't want to appear in court, it is their right. It is their right. It has to be respected. This is the choice they have made, but this should not cause a trial to be halted or adjourned because of their absence. So they have the right to come to court. They can even still come to court and choose to be silent. So this will not withhold the proceedings from carrying on in respect to their rights. Thank you, Attorney. I was saying Attorney Rubergo asking for speech. Thank you very much, President of the Court. As the court was asking about this, when we look at the law handling such a case, a criminal case, Article 178, when an accused chooses not to show up in court, yet they have been summoned legally, the court can still decide to proceed. Following this article and all the previous articles that have been mentioned, this hearing shouldn't be adjourned. Paul RUSESABAGINA was legally summoned. He knew the dates he had to appear in court, and he chose not to come. We have received a report from the prison where he's being held. It is out of his own volition not to show up in court, but legally, this hearing can proceed and it will not contradict.
Okay, iburanisha riba risubitswe gato.
We will adjourn for 10 to 15 minutes, and we will decide on what to do moving forward. 10 to 15 minutes. Thank you.
urukiko rurinjiye.
You may take your seats. We are resuming our hearing session. We are resuming our session. The court is going to inform you on the decision made regarding the absence of Paul RUSESABAGINA in today's hearing. I'll ask the registrar to read the decision made. I'll ask my colleague to read the decision made on the 24th March 2021 regarding the absentia of Paul RUSESABAGINA in this court proceedings. After receiving the letter written on the 24th March 2021, written by the leadership of the Nyarugenge prison, showing that Paul RUSESABAGINA will not be attending the trial of today and that he will not attend any other hearings, as he informed the court in the trial hearing, in the previous trial hearing, after hearing the prosecution and one of the legal representatives. We have seen that the trial will go on based on the law, on criminal cases. He's the one who has chosen not to show up in court. The court therefore finds this hearing of the 12th March 2021, where Paul RUSESABAGINA and his representative had asked that the court would give them time to prepare for this case. The court agreed that they wouldn't be given the time they had requested for because he had been given ample time to prepare for his hearings, and he was always meeting his legal counsel whenever he needed. Also in this case, there were other accused who wanted to have the case begin. The court has therefore found that after reading the decision made, that he should keep carrying on with the hearings, giving him time to work on his defense. Paul RUSESABAGINA informed the court that he will not come back to court because he will not find justice in these proceedings and his rights will not have been respected. The court, after hearing on what was discussed in the proceeding of the 12th March 2021, RUSESABAGINA was informed of when the next hearing would be, though he said he would not appear in court. But after having found that he will not come into today's hearing of the 24th March 2021 without any tangible reason presented to the court, because what he had presented to the court was just asking for more time to prepare for his hearings, and it was agreed that he would appear in court and present his case after his co-accused. But following the law, that it is his right and the right of the accused to show up in court. Article 123 of the law of criminal cases, it has been stated that he had to come without being represented, yet Article 128 of the same law states that when the accused doesn't come to court without any legal reason, yet he had been summoned legally, all the provisions of the first article of 56 and 57 of the law processing this case, after further analysis of these articles of these laws, the court finds that the accused should come to court, but when he doesn't come to court, it will not halt the court proceedings. The court also finds that if the accused chooses not to appear in court, after the case that was done, the case of Ingabire Victoire of 2012, the court had found that it wasn't necessary to force Ingabire Victoire to come to court. But in that hearing in 2012, it was decided that the registrar invite and inform Ingabire Victoire and also Munyagishari, who also decided not to appear in court, but the court proceedings carried on, the trial went on. So it has been evident that there are other accused, including Mujesera Leon, who also decided not to appear in court. He didn't appear in the High Court of Cross-Border Crimes and International Crimes, but he eventually came back to court. So the court finds that when the accused chooses not to appear in court, it shouldn't stop the trial from going on. In the case of Nahimana and his co-accused, the appeal court had agreed and decided that appearing in court was the right of the accused. But if he chooses not to come to court, the trial shouldn't be stopped. Not appearing in court is not mandatory. Also, in the hearing of Gakuba Andre, who had chosen not to come because of some of the evidences against him, the court also chose to carry on the trial in his absence. But he was always encouraged to come to court. Also, in the case of Batista in France, this was a court held in France. In the Court of Human Rights, it was evident that nothing should withhold an accused from appearing in court unless if they have a reason that is tangible enough, but still their rights will be respected. Based on what we have given as explanations and the fact that Paul RUSESABAGINA has not appeared in court without any tangible reasons today, yet he had been informed legally, informed about this date, the court finds this trial to carry on even in his absence, because he's the one who has chosen not to exercise his rights. The court also finds that every time that he will not appear in court, he will be informed of the next hearing, the time, and the venue. He will also be informed of the proceedings and the reports from the previous hearings. And as long as the case is still open, it's his right to come back into these hearings. The court has thus decided that this trial will carry on even in the absence of Paul RUSESABAGINA. He, however, has the right to come to any of these hearings as long as these cases are still open. That's the decision of the court in regards to the absence of Paul RUSESABAGINA, yet he had been informed legally.
Let me also tell you that he was given a computer. The court registrar visited him at the prison and helped him install all the required court software, court case software. Now, Sankara, with his counsel, please step forward. Maître Moïse, go ahead, please. Thank you, Your Honor. Thank you, honorable judges. I thank you for this opportunity given to me to counsel my client, Nsabimana Calixte. Your Honor, let me first thank the court and the whole team, the judges, for their skill in trying this case since 2019. And on my behalf and my client's behalf, we hope that this professionalism will continue throughout the case. Your Honor, we will not take too long because my client has explained most of what needed to be explained. Moreover, he has also clarified his role in the acts that the prosecution is accusing him of. Your Honor, as it's been done before, we want to clarify a few things with regards to the law and related to the arguments we have included in the system. We will talk about 4 points that lead to our request to the court. First, Your Honor, honorable judges, it's the manner in which the prosecution has painted Nsabimana Calixte before he started being prosecuted in this case, as you see on page 2 in the indictment. Your Honor, the prosecution painted Nsabimana Calixte as a person who had always had problematic behavior. They also concluded that the same person had been expelled in the University of Rwanda because of similar problematic behavior, and he went on to graduate in Kigali Independent University. Your Honor, we will not take too long on this point. Even though the prosecution mentioned it in their indictment, they never gave any sort of evidence supporting that claim. But if we raising that point, Your Honor, it's because when a defendant is pleading guilty, such a statement has an impact on the court when they are about to make a ruling on his case. But to be brief, Your Honor, we want to say this. If you check the system with notes and attachments, with the attachment number 200, we gave you evidence proving that the prosecution was wrong in their statement on that point, on that expulsion from the university. Your Honor, you'll see that we've uploaded his degree from the law department. You'll find his school reports from high school and to whom it may concern, issued by the law department dean, which proves that Nsabimana Calixte graduated from the National University of Rwanda. We're clarifying that because this might have an impact on how the defendant is treated by the court. This is evidence that what the prosecution said was not correct, was not true. Therefore, Your Honor, we will not spend too much time on it, but the defendant's behavior needs to be clarified, and the truth needs to be written down in a right way, based on the truth. Your Honor, honorable judges, if one analyzes Nsabimana Calixte's dossier, there's a legal issue here that we want the court to analyze. This is an issue related to the law referred to by the prosecution when they indicted him. When the prosecution says they used the 2018 law, the law about crimes and punishments in general, in the National Gazette on 27 September 2018, the law number 46/2018 of 13 August 2018 about fighting terrorism. Same law in the National Gazette on 24 September 2018. And the law number 59/2018 of 22nd August 2018. Your Honor, honorable judges, in that indictment by the prosecution, on page 4, paragraph 2, prosecution said that the crimes Nsabimana Calixte is accused of were committed between 2013 and March 2019. But if you look at the indictment again by the prosecution, it's obvious that some of those crimes and acts he's accused of were committed before those dates we've mentioned, with the dates where those laws came into force. Now, Your Honor, what we want to prove to the court is that based on Law 334 of the same law about crimes and punishments in general, you'll see that the crimes committed before that law came into force, was published in the National Gazette, must be punished based on the law that was into force during that period, except when that law provides lesser punishments than those provided for in the 2012 law. Your Honor, we wanted to discuss that law issue with the application of law in time, given the time when the crimes were committed. And we also want to prove that the prosecution never conducted that exercise. They said that they decided to apply the law of 2018 instead of that of 2012. Your Honor, we gave an argument with a table comparing the issues, those two laws, but we believe that the crimes or the acts committed before this law came into force were not going to be tried on a law of 2018. And this has an impact on the legal elements within these crimes, because among the constitutive elements of this crime, the legal element needs to be established based on the law that has to be applied. And that is something we want the court to analyze as they rule on this case, to apply the right law. But our position is that the 2012 law is the one that should apply to this case, as we've clarified in our arguments. And this is also in relation with the punishments mentioned in that law, because it's a law that provides lesser punishments compared to the 2018 law. The third point, Your Honor, that we want the court to consider is related with qualification of the crimes. And as we know, Your Honor, with criminal cases, the court analyzes facts, but the qualification of crimes, to say that these acts are included in such a crime and it's within the court's competence to try them, we want to reiterate this. In previous hearings, right after the indictment by the prosecution, it was clear that some acts that the prosecution mentioned were said to be part of different crimes, but when they were really, it was not the case. We'll give you an example, Your Honor. On the act of creating an illegal armed group and being member of that group and participating in a terrorism act and being a member of a terrorist organization. That's the first crime, third and fifth crime, which clearly shows you that if you look at the facts, this should not be three different crimes that a person is accused of. But based on Nsabimana Calixte's explanations, we want the court to analyze this and analyze those qualifications. But for us, we reiterate that Nsabimana Calixte explained that he was the second vice president of MRCD and spokesman for FLN. And that responsibility is what he established as his link with this terrorism organization. So he's clarified that at length. I will not spend too much time on it. It's in our argument. And now, about that issue, the court asked the prosecution to clarify it, and they said it was 3 crimes. They are concurrent, in that the most serious punishment would be applied. When the time for sanctions come, the most serious punishment will apply to those 3 crimes. That's what they responded. I remember that, Your Honor. But if you look at the prosecution's indictment, you'll see that that's the argument they came to. They will lead to their closing arguments. We will not talk about that because it's premature. But what we talk about here is qualification. What was exactly the crime that he's accused of, that he has to answer for? What are the constitutive elements for that crime? And for us, Your Honor, about creating an illegal armed group or being a member of the same group, as he has explained, that of in itself would have been enough. Being a member of an organization implies that there are acts that were committed, and he has explained that. So we want to remind the court to analyze once again the qualification of the crimes and establish individual responsibilities and the crime that they committed. We also want to talk about the framework. We're not diverging from our client's view of things. He has explained what he has done in terms of crime, but we want qualification to be clear. So it's clear that he has pleaded guilty for what he's done. Your Honor, honorable judges, I do not intend to go very much into details. We've clarified our position in our arguments. What we want to raise as an issue is about crime being an accomplice to a crime as it is accused, as the client is accused. Your Honor, honorable judges, the court asked him, you see what the prosecution is saying, the crimes you committed, you plead guilty to that. Would you clarify your responsibility, your role in it, and how you committed those crimes? We want to ask the court to measure that level of responsibility on behalf of Nsabimana Calixte as second vice president of MRCD and as a spokesman, a person who once was a spokesman. What he explained to the court is that he clarified that that's where his responsibility ends. But if you look at the different crimes, including the crime of burning down property, killings committed by FLN troops, we want the court to establish his role, his responsibility in relation to those crimes that imply material evidence, physical evidence. abducting people, robbery, burning down property. Your Honor, there should be good discernment while establishing that responsibility, so we know his responsibility in a direct and his direct responsibility. Your Honor, honorable judges, here is another important thing that the court needs to consider when they analyze the crimes that Calix is accused of. It's the context in which these crimes were committed. And when I'm talking context, Your Honor, I mean something important about how he arrived at the point where he started collaborating with Kayumba Nyamwasa Karegeya when he was still a member of RNC. Your Honor, when he says this, when we say this rather, we're not evading responsibility, but we clarifying to the court that he was in a situation where what he was told or the propaganda within those organizations might have had an impact in leading a person to commit crimes, commit acts that constitute the crimes he's accused of. But the court should appreciate that when they analyze the context at that time when those terrorist organizations committed crimes. Your Honor, honorable judges, we want to talk about what we explained to the court when we wanted to establish that Saimana Calix should be how he should be considered by this court when they make decisions, when it takes its ruling, because there's a reason for us. There's a clear and understandable and direct reason that the court should consider, because those are reasons that would lead the court to give Saimana Calix less punishment. Your Honor, those reasons we want to raise that we mentioned in our arguments are reasons we believe that would lead the court that could help alleviate the punishments. Of course, the consequences of such decisions, we would come back to those when the court takes a decision. That's when we would probably say something that responds to the indictment in one way or another. But we've told the court that Saimana Calix was cooperative at all levels in this process here in the court. Your Honor, we also say that what we want to say is that we thank this court and the prosecution. We have a few things in common, even if you look at the indictment. Saimana Calix was cooperative. He cooperated with with justice. He helped justice to move forward, to take its course, and he provided information that helped during the investigation. And that was a crucial step, Your Honor. When they read the acts, the crimes he's accused of, it could have shocked him because he could have been scared, but he decided to cooperate with the justice from day one, from the day he was interrogated by RIB. It continued with cooperating with the prosecution and with the court. And this is a very important reason why the defendant should have a less serious punishment and prosecution will take the necessary decision. Your Honor, we gave a reason saying that this is the first time Nsabimana Callixte has been brought before a court. This is it's related to the context we want to talk about. This is an important reason because if the defendant and the prosecution, we have this in common, that this is the first time my client has been a good citizen before this case. Your Honor, we want the court to appreciate this, and as they make a decision, it's how Nsabimana Callixte has argued in this case, has pled. And from investigation with prosecution over here, Nsabimana Callixte has always said that he disassociates himself from those armed groups. And this is a very important step, Your Honor, because the individual wants to be reintegrated in his society when the time comes after the court's decision. And, well, about other aspects, the court should use the arguments that we've uploaded. So we wanted to clarify those reasons for which clients should get less punishment. We will talk about the consequences of such decisions because we cannot say anything right now, but the reasons we gave you are mentioned on in the indictment in page 35. The prosecution has acknowledged that his guilty plea was sincere, and that the information he shared has been very crucial, very helpful in this process. And all those elements should concur to make the court make a decision while it makes it gives the punishment. That's what we wanted to share with the court. And about the prosecution's requests, we will have time to talk about it. I thank you.
Thank you very much, Sankara. Do you want to add to this? I have nothing to add, Honorable President of the Court. You may take your seats.
Okay, reka dukomeze ngira ngo ntagiye muri byinshi cyane. Muzi amateka y'uru rubanza, imanza zahujwe, uko Nsabimana Callixte yaratangiye kuburana, bagenzi be bari.
You know how Nsabimana Callixte presented his case. You know how this case has been proceeding, the background and the context. The reason why I'm highlighting this, it's because I want us to go back to their request. What we had agreed that they had started with their proceedings, and once their proceedings are concluded, we would discuss. And it would be helpful for each one to know how their cases are developing, so that we can also have a program of the proceedings that are upcoming. We don't want this to take a long time. We would like to hear your input, your advice. But what we are looking at when we look at the roadmap of the other accused, because Sankara's case had already started, but we have looked at different other factors. The first is the other duties that the court has. This venue also has different other cases being tried here. So I want us to agree on the hearings and what time we can allocate to these cases. The first principle that we want to discuss is this. We were thinking, can we have these proceedings 2 to 3 days every week? That would be the first proposal. That means that we would have between 8 and 12 cases opened. So are they many? Are they less? This is why we are presenting this to you. And in regards to the prosecution, we've looked at the different indictments that you have. You have the one of Saimana Herman, which has 9 pages. We have the one of RUSESABAGINA and the co-accused. It has 292 pages. We have the indictment of Saimana Jean Damascene, which has 121 pages. So we were asking if the prosecution could take 5 to 6 meetings to review this. If there are many, we discuss this. The third point, for the other accused, because there are around 21 accused, we were planning on having between 5 to 6 hearings. But as we were arguing amongst ourselves as judges, we realized that it could go beyond that, but it would depend on the crimes that each accused is being accused of. But the principle is having 1 or 2 accused appearing. So let's assume that one can speak a full day or a half day, or 2 accused take a full day. So these are just plans that we are proposing. I cannot quantify here the situation that we have at hand, but these are the proposals that we're giving to you. For those who are here for compensation, we were planning 3 to 4 hearings based on the number of those who are here for the compensation case, 92 of them. Then we will plan to have witnesses. It will depend. It will depend on the court and the accused, but we were also thinking of having 2 sessions for witnesses. Then after that, as you are all reaching your closing remarks, closing statements, responding to what the other party discussed, we were also thinking of 2 to 3 hearings. So if you can please cross-check with these figures I've given you, or these proposals that I've given you, and let us know if there would be many. So with all of those explanations given, if we were to follow this, if we take every hearing to start at 8:30 and we take a lunch break at 12 and then come back at 1 o'clock, and all these other hearings that I've presented, 8, 10, 12 hearings per week, these cases could last between 4 months, 3 months and a half, and 4 months. But all of that will depend on what we will agree on. We hadn't given you a schedule. We had just given the schedule for the other cases, but for this case, we had to agree on these hearings. So these are the thoughts of the court on the roadmap that you had requested for. And the court had actually worked these out before. So we would like to give you 10 to 15 minutes to discuss on this roadmap. Prosecution, do you think we have enough hearings? Are they many? Are they little? What would you say to that? Thank you, President of the Court. Thank you, judges. As you have expressed, 2 hearings in a week, every week. To us, as the prosecution, we are very fine with this, given that you'll give us 6 hearings. We think this will give us enough time to present to the court all the evidences that we have and the indictments we have. If it was short, the court will see this, and as you're saying it, the court will probably add more time. This can't be quantified, but the prosecution will respect and follow this schedule given to us, as long as we're given the date earlier, so that we prepare ourselves in advance. Thank you very much. They were reminding me that you mentioned 2 days, but we had said 3 days. So if it's 2 to 3 days, we have no problem with it. What we're asking the court is to inform us of these days earlier. So tonight, you will have known the dates set for the hearings, based on what we will agree on. If we agree 2 days in a week, you get your 6 for the 6 cases. We will be seeing that in the court hearings, by the way. In the sessions, it will be evident. But if it's 2 to 3 days, we will submit it to the others and hear from them. We are ready. Let me ask the legal counsel of the accused. According to the prosecution, for them, that is very fine. But let me ask the legal counsel. What do you think of the 2 to 3 days hearings? What do you think of it? Thank you very much, President of the Court. Thank you, judges. Given the hearings that, as the court has seen this, it's not exhaustive. Sometimes it might change based on the proceedings in court. I will not say much on this, but though we have so many accused, these hearings and the cases can be faster than we anticipated. But what I want to highlight is the days that the court is presenting, 2 to 3 days in a week. We said 2 to 3. Yes, 2 to 3 in a week. Honorable President of the Court, honorable judges, as the legal counsel of the accused here, who have other cases open, all the attorneys who are here have other cases, other clients that we are handling with. Personally, I think those are many days. I would propose, or the request I could make personally would be that if we have a day, a week, Friday, make Friday a day for this. And most Fridays we tend not to be busy with other cases. So we believe Friday would be a free day for us, a free day for many attorneys. But if I would come back to this, it would depend if the hearing, if we were all coming to all these hearings, all of us, we appear with the accused, if it carries on like this, that's where I'm saying that those days would be many. But if there was a possibility that there would be an attorney for a specific case, a specific accused, not all of us appearing at the same time, then that would be different. That means if something else was mentioned in the hearing, the other attorneys would have access to the report. But if it was just to be one attorney with their client, then that can be worked out. So you are proposing one day in a week and Friday. Thank you for reminding us on that. I didn't specify the days of the week, but Friday is quite difficult because that day there are other cases that we have. But if the hearings are not being done here and they're done elsewhere, this is something we can think about. But now as we speak, Friday would be difficult. So even the days I'm proposing of the week, they will not be on Friday, unless if there is one specific Friday that we have set aside for these cases. We are saying this because we want to reach a consensus between us. Thank you, President of the Court. Let me ask if there is any other attorney who has something to say to this. Thank you, President of the Court and honorable judges. My request in regards to this roadmap, so that we are all able to meet what the court requires of us. My colleague has asked for one day a week and on Friday. I will agree with her because Friday is an easy day in general for us. But I've just told you that Friday is not possible. I don't want you to consider Friday because of the other existing cases. Let's first agree on the days in a week, 2 to 3 days. But the specifics of the days is something else we can discuss. But can we agree on keeping it to 2 to 3 days? I was thinking of only one day in a week, because us as attorneys, there are days people and other clients require our services. So that's why we were proposing Friday. But if the court finds Friday to be a difficult day, then one other day during the week, that would be fine. Another request that I have is that every time a client doesn't have their attorney present in that day, that the court can allow that attorney to pay attention to other matters and other cases, but also receive the update of the court minutes. I think my colleague had mentioned that. Then to do with the hours, 8:30 to 12, then 12 to 1 lunch break, but we make sure that a hearing doesn't go beyond 3 p.m. That would allow us to also focus on other matters that we have. Thank you. Thank you, Attorney. My name's Attorney Eamon Kwaja Mahoro. Your colleague has something to say. Thank you. But you are not saying anything to do with the compensation cases. You're not also saying anything to do with the days in a week. Are you agreeing on the 2 to 3 days? We need specifications. You're not even mentioning anything to do with the accused, the number of the accused people. Thank you, President of the Court. I was thinking 2 to 3 days, even 3 days, President of the Court, that would be very fine. But I support 2 days because as the program that we have, I find that we use 3 days. I think we were here even yesterday. So if we say 3 days plus the day we were here yesterday, that makes it 4. Yesterday we even had a challenge. But we spend our time here. Sometimes we come and we don't know when we are going to leave. So I would propose that we do just 2 days, plus the 3rd day that we have to be here. We were here yesterday for testing. So I propose that we just do 2 days, maximum 3 days. Honorable President of the Court, one day, as my colleagues were saying it, we never even discussed this as a team of Defense Counsel, but I'm thinking one day would be little because these are long cases. The 4 months would actually turn into 8 months. Just as our colleague said, Moise, as Moise said, it's almost 3 years. So if he's been here for 3 years, the case has been going on for 3 years. So for us, we're thinking if we could work on the days so that we cut down on the time these cases take, that would also be very helpful, depending on how the cases have been prepared. But as I stand here, I would like to ask the court of one thing. I've asked for 2 days, but as my colleague has said, when one attorney hasn't come, the trial shouldn't stop. The trial should go on. I believe we have some of our colleagues who are here. For the accused not to appear as if they don't have defense counsel, they can come, but a colleague can stand in for a legal counsel, a defense counsel who hasn't appeared in court. So I don't think there would be a challenge with this, but the trial should go on, and the defense counsel standing in for the one who is absent can carry on and then update their colleague. I want to also highlight the time we close our hearings. Some do not live nearby, and this affects even some of our work that we do in preparing for the development of our cases. I would like to request that you also work on the timing of the hearings. I thought this would take a few minutes, but I think this process is taking longer than expected. I think this is going to take time. Let's ask them to just go straight to the point so that we conclude on this issue. We have two three defense counsels who wanted to say something. Are you representing the compensation cases? Yes. Thank you, President of the Court. Thank you, honorable judges. Us as those representing compensation cases, the 3 days that you've given us are enough for us, but we are requesting that in the roadmap, there will be time for closing submissions, because only 2 have responded to the closing submissions in regards to compensation. So we're asking that those who haven't made their closing submissions and they haven't uploaded them in the system, they should upload them in the system. And we're also asking that in regards to we are asking for a tea break between 8 and 12. We are also requesting, we don't have a challenge of appearing in the hearing because we are a team. We will always appear as a team for the purposes of justice. But if I have forgotten anything, I would ask my colleagues to add something. Thank you, Honorable President of the Court and Honorable Judges. Our colleagues have said we spent 3 days here. The third day wasn't elaborated. We have a challenge when it comes to coming here for testing. We don't know the time to come for the testing. Sometimes we come and we spend a whole day. Sometimes they can even call you when you're in another court session. So we would like to ask that we get to know the specific time we come here for testing and we organize ourselves. Also, in regards to the 3 days, we find the 3 days sufficient for us, unless if there is any other challenge. Now, to do with the 2 days, the court has said that Friday is practically impossible. It was also our request for us to appear on Thursday and Friday. We could ask other legal support or other colleagues of ours to come, but we're asking the court to go back and assist us in finding out if Friday can be worked out so that we appear both on Thursday and Friday. Thank you, Mr. President of the Court. I find that my colleagues have mentioned everything we needed to say, but I want to highlight on the 8 hearings in a week. There are many. A month, sorry, not a week. They are a month. 8 hearings a month. We find 2 days in a week to be enough. Then 1 day for testing. We use the 2 days well. We find that it would be helpful, since we have so many other cases that we are following, and when we don't appear in court for those other cases, our clients are not happy. Thank you. So let's agree on this. Let's take, this should have been done actually in the first hearing. But these cases some had already started to be tried, such as Sankara's case. So this should have been done in the preliminary hearings. But now this is why we have to come back to this, so that we get on the same page. So the first thing is this. We agree to start at 8:30 to 12. We take a lunch break to 1, then 1 to 3 p.m. Is that fine? Someone has also asked for a tea break at 10:30. This is something that can be looked into. But if we agree that we start at 8:30 to 12 and then 1 to 3, I think that's fine. So if we take 2 days in a week, Some have said 1 day, others are saying 3 days, but let's agree on this. Is 2 days fine with you? Now, then we look at when the 2 days would be happening in a week. How about Wednesday and Thursday? Where possible, we can do Thursday and Friday. But if it doesn't happen because of the other courts that try their cases here, we will stick to just Wednesday and Thursday. I find that no one has a problem against that. The number of hearings and the cases, no one has presented any challenge around that. Even the team of compensation have agreed that that's very fine with them. So if we just take these 2 hearings, Wednesday and Thursday, and if there are any changes, we are always together, we will all manage this together. I find that there will be no challenge with this. There is a problem that was highlighted, the one to do with closing submissions to be uploaded in the system. We don't need to look into that. This is legal. Closing submissions should be uploaded in the system as soon as possible. Besides the hearing of tomorrow, but we want to agree on this. Legally, the time to upload in the system is known, so I think that should be respected. The only challenge that I think we have left, I don't know if we'll decide this, but I don't know if we will agree that the accused come to court without their legal counsel. Some didn't agree on that because they said this case is one, it has connecting links. All the accused have to come here with their legal aid. So I'm wondering, why are you bringing this back? Attorney Moise, why is this coming back? Because we had previously agreed that this is so many cases into one with connecting links, and we all have to be here. I'm calling out Moise because Moise is the one who is here in court, and he's gone a while.
Thank you, Your Honor. We gave that position because a ruling had been taken by the court because of RUSESABAGINA's request, following RUSESABAGINA's request, and the trial was postponed because he didn't have his counsel on that day. But I think that as a principle, every party ought to be represented. It would be much better. But because of this case, because some individuals need to be tried on a particular day, and obviously it'll take many days, that's why that issue was raised once again. I don't think it would be appropriate for the court to decide that the defendants would appear unrepresented, but to remain professional. If people need to come to court on a particular day and a certain attorney is not going to be present, they need to notify the court ahead of time. Thank you.
Okay, ngira ngo kuri icyo
All right. I just clarified that already, like I did sometime earlier when we have 40 people in a case. It was about terrorism charges. The court cannot decide for defendants to appear unrepresented. But like Tony Moyes just said, anybody who cannot show up, they need to notify the court ahead of time. That's understandable. If it's a defendant or an attorney, they need to notify the court, and then we would deal with it on a case-by-case basis. We cannot decide on anybody appearing or not appearing. So it's your duty to represent your clients. But if there's any problem stopping you from appearing, then you notify the court ahead of time. Is that okay with the roadmap? Any other question? See the prosecution consulting. Did we forget anything? All right. So if we all agree on it, well, I hear my colleagues tells me somebody wants to take the floor. And a defendant? Please step forward. And what's your name? Nikuzwe Simeon is my name. Here is my request. As you decide on this schedule, the roadmap, please consider the health and living conditions of us defendants. Because sometime you'll get up, you go to bed feeling well, but in the morning you're not well because of the living conditions we have. So you should consider that. Please clarify. I don't understand that. We normally consider those. Whenever somebody has a problem, we analyze it and deal with it. If anybody is sick or weak, that's usual. We take that into account. So what's the problem exactly? Can your attorney clarify, maybe? The conditions, our living conditions, our nutrition, it's not easy at all. We do not have good nutrition, and not all of us are equally healthy. Some individuals get assistance from their families. They get a mattress, for instance. Others sleep on the floor. Sometimes you'll go to bed feeling well, but the next day you're not feeling good. That's, like I said, the defendant's living conditions are taken into account. If an issue is raised, we deal with it. And the living conditions is something you can also raise with the prison. But if you have an issue related to the trial, then you raise it here and we deal with it as the court according to the law. Is that clear? Well, what I wanted to say that it's how sometimes you're not feeling well in the morning. Well, like I said, if you have such a problem, please raise it with the court, and then the court will rule on it. Thank you, Your Honor, honorable judges. My client, Nikuzwe Simeon, wanted to raise an issue about living conditions in prison, but the court has given clarifications. Thank you. Anyone else? Because we want to move forward. We're talking about the roadmap for this trial. To Mr. Jean-Claude, thank you, Your Honor. Here is what I want to say. Our attorneys and Like the previous speaker said, the attorneys should help their colleagues when they are unable to come to court. My point is this: when an attorney is unable to come to court, you know, Your Honor, a defendant could come here unrepresented, and then they need to respond to something, and they don't have help. So to avoid that, if an attorney is going to be absent, they need to talk with their colleague so they can represent their client. Thank you, and I think that has been raised, and that's among what we've clarified already. We said this: if an attorney has a problem, we'll deal with it, and what you say is provided for by the law, so there's no problem. All right, if there's no one else, well, people are still coming back to the same issues. Okay, go ahead. Please move closer to the microphone. State your name. My name is Senjimana Herman. Thank you, Your Honor. Thank you, honorable judges. We have been discussing about the roadmap for this case, and like the previous speaker said, sometimes we face problems. As we heard, the trial could start in the morning until in the afternoon, and between 10 and 11, we eat corn in prison. Now, if we spend the day here, we leave the prison early in the morning. We don't eat any breakfast at all. And if you go back around 4, you haven't eaten any lunch, that would be a problem for us. And maybe you could talk with the prison so they can bring us that meal, that lunch here, so we can eat. That'd be helpful. So please think about that, because when you've eaten something, then you can think properly. That's understandable. I get it. Attorney, go ahead. Thank you, Your Honor. Herman's idea is very clear. I have nothing to add. Thank you. We'll talk about that issue. We'll talk with prison management about the possibilities. But what you say is clear. If that's true, then it's clear. We'll talk with the prison management to see what they can do. And based on what they tell us, we'll adjust a few things with the roadmap. Well, you don't want to move forward. This was an easy issue. We were talking about a roadmap, and then it turned into living conditions in the prison. Okay, this lady here, but this should be the last speaker on this issue. But I hope it's something different from what the previous speakers have mentioned. If not, then we need to move forward. If it's similar to what they've said, then it's been handled. Thank you, Your Honor. it's been said, but you should know this. If you find, if it's agreed that we should get that corn toothless, please think about that when it comes to that lunch, to that food. Well, like I said, we'll talk with the prison management. If when we for the days we spend here for this case. Thank you, Your Honor. What Mukandutie just said is clear, and we have nothing to add. Thank you. Now, this is agreed. The roadmap is agreed upon. We'll move forward. And now the registrar and other colleagues will put this down so we can communicate the clear roadmap to you right at the end of today's proceedings. The days for the next hearings and the related issues. The prosecution, go ahead and explain the other acts you want to talk about, and the basis for those accusations. And we're talking about Herman, RUSESABAGINA, Sabimana, Sankara, and other co-accused. Thank you, Your Honor. Thank you, honorable judges. Like you say, the prosecution is going to explain how the crimes were committed by the remaining 20 defendants, and we will provide evidence. And as the court has explained, Sabimana Calixte, because of the progress of the trial, and he had to finish his plea. Today, we want to clarify the evidence about those crimes, but we want to first give the context. What we call context here is this: we need to explain in a global manner how these crimes were committed, reminding you that they were committed in 3 districts: Nyaruguru, Nyamagabe, and Rusizi, reiterating the time of those crimes, when those crimes were committed, and also reminding you of the victims, including young children, the property that was destroyed, and other crimes and other forms of violence committed then. This context, Your Honor, will help us to explain how those crimes are committed. And it's about each and every one of those 20 defendants. They played each a different role in committing those crimes. So the context will help us establish the crime used in context. Well, in a different context, because it was a criminal act. We also want to give you show the connecting link between these the crimes committed by these defendants, and that's necessary in clarifying the crimes committed. And last, this context, Your Honor, honorable judges, will also be based on law and evidence. And as you've seen in the context and in the dossier, the prosecution requested that 2 witnesses be heard here because they have information to share with the court, clearly explaining how those crimes, these terrorist acts were committed. We also want to hear a witness who wants to clarify how different terrorist organizations were created. That request was introduced recently, Your Honor, and you've seen that request, and we request the court today, as we explain the context, that the court allows us to introduce these witnesses. But you did not explain what the witnesses would be coming here to do. We've seen the requests, the parties saw the request, but you did not explain what they'll be coming here to explain. Oh, you've alluded to it, but please elaborate so we know, so all parties know what the witnesses should be talking about. Thank you. Here is what they'll be talking about. But first of all, let me talk about the context. The first part in this context will be about explaining terrorism acts. We will clarify what a terrorism act is, and we will give case law. We will define terrorist organization, because these crimes include terrorism acts and terrorist organizations. So we need to define all those. So those, well, you want to explain that in general. Yes, we do, but it will be in relation to the defendants today. So the first witness that we'd like to be heard in this proceeding is a witness who has information clarifying the genesis, the tangible evidence that establishes the connecting link between these defendants when it comes to the planning of terrorist acts. So it's a witness, and the witness would give their testimony, the information. I'm not going to speak for them. So it's about how these terrorist acts were committed, and especially the genesis of those organizations, with evidence. The second witness we want the court to hear is a witness who will share information about how those terrorist organizations were created, their plan, their agenda, which corroborate the evidence we gave in our indictment. We want the court to hear these witnesses because for the sake of clarifying to everyone that what we're talking about today has evidence. There are laws about that, and the people who played a direct role in it can clearly explain it. So this is the appropriate way to go about it to establish everybody's responsibility. Well, it's not clear. It's still not clear. The question is, these witnesses you're talking about, what kind of witnesses are those? Are they testifying about the acts even when are they context witnesses? What kind of witnesses are they? Because you haven't even clarified the crimes. Are they witnesses for the context? Please clarify. Your Honor, that's how I explained when I started. When Simon Calixte, who gave his plea, we want to keep explaining the crimes committed by his co-accused. But for every co-accused's role to be clarified, we want to give that context in which they were committed. So those are context witnesses who prove that that common commission of crimes is supported by evidence that we can give. So these are witnesses for the context. And this is also in relation to what we're going to explain. My colleagues will we will also talk about this. It's also related to our request. It's in the system. Thank you, Your Honor. If this is not very clear, it's because we haven't yet clarified the reasons why we want them to be heard. We were going to come to that, but the thing is, the witnesses we want to be heard are context witnesses. We're not yet dealing with the substance, but we're talking about the context. We want to prove that these 21 defendants before the court are accused of terrorism acts committed within different terrorist organizations that evolved differently. Those who were able to read the indictment saw it. We elaborated on that. So as we explain the context, we want those witnesses to come and talk about that context and to talk about those terrorist organizations, how they evolved, and the role different defendants here played within those organizations. Your Honor, if it was not directly understandable, if you allow us to carry on and explain why those witnesses are important, the court will understand. We were only announcing that we've introduced a request that the court allow us to hear context witnesses, because that will enable us to deal with every crime. So you're saying that these are witnesses who will clarify the context of those crimes in general. PN Claudine, do you want to add something? Thank you, Your Honor. It's about the question you just raised. They're not really explaining the context as such. We're explaining. We are the ones explaining the context. But those witnesses have evidence or are the evidence for that context. So go ahead and explain. When we come to that, we will hear the kind of evidence they are bringing to that context. Go ahead.
As it has been discussed before, and as we are trying today, the first thing that we would like to present to the court is the explanation on acts of terrorism. The reason why this is crucial in this trial, as it is evident in the indictment documents and as it was explained to the court in different documents, we have 21 co-accused who are here because of the connecting link of the acts of terrorism. They were members of a terrorist group, and some of these crimes were developed at different times. So we find that it is very necessary that we first explain on the crime of terrorism, present to the court on all the works done around armed groups and what is mentioned in this case. Honorable judges and Mr. President, terrorism or acts of terrorism are not new in this hearing or in this case, but when we look at the different documents that we have, we find that acts of terrorism have always been here, but they changed in different times. When you look at the number of acts of terrorism, when you look at how these crimes were committed, and the intent to commit these crimes, we will explain this using what the expert reports around these acts of terrorism said. When we look at what these acts of terrorism entail, we will use the law, we will use random law, we will also use international law, and we'll come back to what was agreed by the court in different hearings and different cases around acts of terrorism. Mr. President, we had mentioned it, that acts of terrorism are not a new concept, and they are not mentioned in this hearing or in this trial for the first time. We are basing this on what was written by one of the experts. But before we talk about this expert, I would like to say that all the documentation used, the rulings, all of this has been uploaded in the system, and some we will not have to go back and read it, but all of this can be found in this case file in the system. The option around terrorism and stating that terrorism has been here for a long time, he said, Mr. President, if we were to translate this in Kinyarwanda, the prosecutor explains this text in Kinyarwanda.
Ya kera cyane gusa yagiye ihinduka mu buryo ikorwamo cyangwa se muri forme zayo.
This author talks about acts of terrorism going back to 2 millennia, but terrorism has reincarnated and it has changed in the way it is done and the frequency in which it is done. The reasons and causes of terrorism, they can either be, they can look at when we go back to 2 millennia. However, in recent times, terrorism has happened more frequently than it did in the times past. And the intent with which terrorism is committed in this time has also changed. So, acts of terrorism and terrorism, if we want to trace them, we can go back to 2 millennia back. And terrorism has always been done. Terrorism is committed by individuals or by terror groups. And we'll come back to these reasons. Mr. President of the Court, today we will not Today, we find that terrorism and acts of terrorism haven't been categorized into international crimes, but since they have been committed in different countries, and when we look at the consequences, we find that some laws were written to fight against terrorism and to punish acts of terrorism. This has been done at national levels or at international level, where countries have written accords and agreements, and these we will come to. So, Mr. President, even though we are talking about the crime of terrorism, which hasn't been accepted or approved as an international crime, allow me to interrupt. Allow me to interrupt. Someone has raised their hand at the back. Let's hear them out. Let's take 5 minutes so that whoever needs to go for a bathroom break can we take a short break for people who want to use the bathroom?
urukiko rurinjiye.
The court is in session. You may take your seats. The hearing is resuming because some people wanted a bathroom break. You may carry on, please. Thank you, President of the Court. We were saying that acts of terrorism that were committed in different countries, whether at the national level or cross-border crimes, international level, this is the reason why laws were put in place to punish these crimes. Agreements have been made, accords have been made, as we presented in our indictment file, and we will not come to this, will not come back to this. Mr. President of the Court, we will explain acts of terrorism based on the law and what was written by experts and what was ruled in courts. We want to begin with the definition given by the Rwandan law, and we'll connect that to international law and what was ruled in courts and what was written by different experts. We will use the law of 46/10,018, the law of the 13th of August 2018, and we are looking at Article 2. This categorizes the crimes of terrorism. When you look at Part A of this article, which stipulates that acts of terrorism are all crimes that are against the security and the life, the freedom, the peace, grave injury and death of any person, a person and a group of people. This can affect the life of a person, their property, government property, environment, and other properties. These acts of terrorism, which are mentioned in Part A, will state that acts of terrorism have been used against a sector, a people, a government, a nation, to frighten them, to hinder them from doing any activity or work, hindering them from doing any activity or following any principles. Another purpose or objective, according to this article, is to hinder the activities or work of the government which are deemed for the people. So acts of terrorism will hinder this. Another third provision on acts of terrorism are for the incitement against the government and leadership in the country. As we said, that as this article stipulates, we find that acts of terrorism can be grouped in two, or they are done in two ways. As we find it in Part A, we'll find that these acts of terrorism have been committed according to the law. These are acts that are against the law, criminal law. And these are acts that are criminal, but which are later turned to criminal, which are later turned into terrorism acts, but they are still against the law. The second part of acts of terrorism, as is stipulated in this article, we will find them in Part B, where the law states that they are called acts of terrorism because they hinder work of development, work of support, empowerment, work of leadership or help. And these will teach, they will train, they will test, they will try, they will incite, they will frighten, they will betray, and they will prepare or give weapons or other resources. And these acts of terrorism can be done by one person or other people, as stated in Part A of the article. Mr. President, we find that we need to explain these articles, these laws, vis-a-vis the indictments that we have, the accused in this case. As we have seen it in Part A, we were looking at acts of terrorism which are against the law. These can hinder life and put people's lives at risk. But the second part, we find that there are other acts that can be deemed as acts of terrorism, or these are underlying acts that work hand in hand with acts of terrorism. These are works that can include giving support, giving resources, betraying, teaching people and inciting them to commit acts of terrorism. So, Mr. President of the Court, we will come back to these when we go into the details of acts of terrorism and all the indictment details vis-a-vis each accused who is here. We will look at places where people were killed, properties were burned, properties were looted, and we'll find that some of the accused here are accused of acts of terrorism, though they didn't even reach there, but we find that the law is still applicable to them when we look at Part B of the provisions of this article of the law. Mr. President of the Court, this definition of terrorism is not just for Rwanda or Rwandan law alone, but this is also a definition that has been visited more than once in international law, international accords, international agreements, where we just give one example. We can look at the agreement between African Union fighting against terrorism. In the first article of Part 3, we find these in the agreements where they define acts of terrorism and terrorism. And these rightly meet what the Rwandan law stipulates when it comes to acts of terrorism. We are not going in the detail of this, but we're just presenting that these are detailed and these meet what the Rwandan law says. As we had just said, it states terrorist acts means
physical integrity or freedom or cause a serious injury or death to any person, in number or group of the general public, or any segment thereof, to do or to abstain from doing any act, or to adopt or abandon a particular standpoint or to act according to certain principles, or disrupt any public service, the delivery of any essential service to the public, or to create a public emergency, or create general insurrection in a state. Point B, any promotion, sponsoring, contribution to, command, aid, incitement, encouragement, attempt, threat, conspiracy, organizing, or procurement of any person with the intent to commit any act referred to in paragraph AI to III. Monsieur le Président,
Your Honor, in these two sections, we find that explanation and that definition when people commit acts against people's lives or destroy property with special intent or other will or another plan. Even during this second part, where we've been talking about acts that are normally not prohibited by the law, but that are turn out to be against people's security and life. Those could be acts of incitement to commit those crimes mentioned above, and those match what's provided for in the fourth section of that law, and this first article of this convention we mentioned to the court. So we find that among those two articles, there are two things. One is the act that is committed. The two types of acts. There's also the intent. So that intent is also provided for by the law, as we've seen in these articles. We also find that this is what was confirmed by different scholars on terrorism, even though they also added a third element that we will clarify to the court. Let me go back to the intent. Special intent is this. The special intent in committing these acts is this. It's based on political interests or personal beliefs, religious denominations, or ideology. So those acts that are committed constituting those crimes, there's also that special intent that seek to stop people from accessing the usual services or putting a government under pressure to adopt certain measures or a certain direction or abandon a certain direction. So those are the reasons behind it as defined by different scholars. And if we go back to what what literature says, we wanted to clarify to the court how all those parts converge to the definition for terrorism. Todd Sandler, as we've said earlier, when it comes to those two elements of a terrorist act, Todd added the third element about people who are subjected to those terrorist acts, or the people targeted by those acts. He says this in his own words.
The definition of terrorism concerns the audience that terrorists seek to influence through the brutality of their violence. By trying to make their violence seem random, terrorists create a general atmosphere of anxiety wherein everyone feels at risk. Tutarasobanurira
Before we explain that, let's also add what another scholar has said, which complements what's been written by Cindy Combs and colleagues. And they wrote a book about terrorism. They clarify the elements that constitute that act for it to be qualified as a terrorist act. They wrote the book called the Encyclopedia of Terrorism. They established that for an act to qualify as a terrorist act, they say this:
sentences of war and theater, a dramatization of the most prescribed kind of violence, that which is perpetrated on innocent victims, played before an audience of fear for political purposes.
Your Honor, having mentioned those three elements that legally constitute the act with regards to the intent, these two scholars have introduced the third element of the audience, that means the people targeted by those acts. What they establish is that, they clarify is this: these acts are committed in a random manner. The randomness of those acts, the example in this case, we will not mention the individual, the prosecution versus some defendants here on the crime of killings, murder, and terrorism. The people who were killed during these terrorist acts, there was no specific reason for them to be killed. There was nothing that explained the reason why they were targeted. But this killing, within this terrorism context, is done against those persons with the intent of instilling fear and anxiety, with the ultimate goal to put pressure on the government or other institutions to adopt a certain direction or adopt certain measures, or abandon some measures or a certain direction as a result of that pressure. And we would explain that killing, that's an example we took, that killing is used like a strategy to achieve their own political goals. Sometimes it's for religious beliefs or other reasons. That's what these two scholars say, that those terrorism acts have a randomness to them, but also to instill fear and anxiety within the larger audience, not just the local, the specific area where it's committed. Your Honor, once we start talking about how these crimes were committed by these defendants, we will apply these theories to the practical aspects of their crimes. So they mentioned those two aspects, the acts that are mentioned in criminal law. There is that specific or special intent. There's also the element of instilling fear and anxiety within a larger audience, larger than the specific location where the crimes are committed, and that is done as a strategy to put pressure on governments or institutions for some specific purposes. This matches what we have mentioned, that is provided for by the law, and we promise that once we start analyzing how the crimes were committed, we will match those crimes with these elements that we've just mentioned. Now, this definition of a terrorist act is provided for by the law and different scholars. It was also mentioned by different courts that tried terrorist crimes. We'll mention one court. There are many, but for the sake of the stage of this court, we mention the decision by the Special Tribunal for Lebanon, where they clarified the elements that need to be analyzed to qualify a crime as a terrorist crime. In a case tried by that tribunal, they clarified what needs to be
judicial practice of states, events the formation of a general opinion juris in the international community, accompanied by practice consistent with such opinion, to the effect that a customary rule of international law regarding the international crime of terrorism, at least in time of peace, has indeed emerged. This customary rule requires the following three key elements: the perpetration of criminal acts such as murder, kidnapping, hostage-taking, arson, and so on, or threatening such an act. The intent to spread fear among the population, which would generally entail the creation of public danger, or directly or indirectly coerce a national or international authority to take some action or to refrain from taking it when the act involves a transnational element.
As it was explained by that tribunal, they also say that qualifying a terrorism act was based on international conventions and resolutions by the United Nations and laws and court decisions in different countries. They found that it's like all those converge to one thing that can be considered as opinio juris, or a practice that needs to be accepted internationally, and they also find that it needs to be accepted as a customary rule of international law, where three things need to be done, including the act, which is an act that is prosecutable, example, murder, abducting people, or threatening people with those acts. But they also mention that intent to instill fear and anxiety within the community, to be used indirectly or directly as pressure on a certain institution nationally or internationally to take some measures or renounce some measures. Third element that we find is related to what was being tried was that the act has to be cross-border. And this is related to cross-border terrorism. Your Honor, that decision is related to what we were explaining within the Rwandan law or international conventions, and that's what literature clarifies. The other element is about the victims, the people targeted by those acts. We told the court that terrorism acts are committed against one individual or many individuals, but the intent is to send a message to more than those specific persons. Gerard wrote about that in the book called The Mind of a Terrorist. He has shown that there are direct victims of those terrorist acts, but they are not the only ones targeted, because what is done to them is intended to send a message to many more people, which is used, as we said earlier, to achieve their ultimate goal, as they put pressure on governments or international organizations to do or not do certain things. This scholar also says this. What we mentioned, that those acts are committed in a random fashion, that is very it's very frightening, because when you see that people are targeted randomly, it means that anybody could fall victim to those acts wherever they are. Your Honor, having given all those explanations, we've shown how these different acts are different from ordinary crimes. And in that manner, the intent is to use the direct victims to send a signal to many.
Is intended to convey a message to the audiences of attention, and it is the fact that the victims are unarmed and the randomness of the act that could occur to anyone at any time, anywhere. The abnormality of the act that so compels horrified attention. Terrorism, then, is a particular species of political violence. It is violence or the threat of violence against non-combatant or property in order to gain a political, ideological, or religious goal through fear and intimidation. Usually symbolic in nature, the act is designed to have an impact on an audience that differs from the immediate target of the violence. Monsieur le Président,
Your Honor, that's what we had clarified earlier. That this shows that those acts are committed against unarmed civilians, and they're committed randomly. And when we talk about where some FLN fighters opened fire on passing vehicles in the road, they don't know if a specific person's car is going to be on that road, so they say, well, we shot somebody we wanted to shoot. It's a random act, it's indiscriminate, and it could be done to anybody, and that's how it creates that sense of fear and anxiety, because anybody, wherever they are, they say, well, it could happen to me, anytime, any place. That's what the scholar called the abnormality of the act. These are abnormal acts, and that's what terrorists use as a weapon, as a means to achieve their goal, which is political or religious or ideological. Your Honor, as I conclude in this section, we want to say that, as we said in the beginning, these are acts that were committed for many years. And these are acts that can be committed by individuals, lone wolves, or committed within groups of people, terrorist organizations. And this is within the context of this case, because the people accused in this case belong to different terrorist organizations, as we will explain. So, to conclude in this section, we want to reiterate that we've clarified the elements constituting a terrorist act as per Rwandan law, and which is similar to what international conventions and have certified, and it matches literature if you read what different scholars have written. So if we apply this to specific defendants, we will see the relation. So my colleague will continue and explain what a terrorist organization is. Yeah, carry on, please. Thank you, Your Honor. After my colleague has clarified what a terrorist act is, terrorist by one individual, as we've seen with the FLN elements in Nyabimata, Nyaruguru, Kitabi, and elsewhere. And she's also clarified that a person who's not in the field on the ground, like one of the defendants said, that is saying that he is not responsible for what was committed by FLN fighters. My colleague clarified that even when you do not go to the field, you can answer for some acts of funding, giving instructions. That's another form of responsibility. The acts my colleague just explained were committed within the framework of terrorist organizations that we're going to clarify, define. And we want to explain to the court what constitutes a terrorist organization, how it qualifies as such. We will also mention different terrorist organizations mentioned in this case. Your Honor, the Rwandan law number 46/2018 of 13 August 2018 about fighting terrorism in section 2 paragraph 11 defines what a terrorist organization is. Terrorist organization is a group of people operating based on an agenda to commit terrorist acts. Your Honor, Rwandan law clarifies that for an entity to qualify as terrorist organizations, it has to meet two things. One is, it means it has a program. It's structured. It's organized. It has a leadership. It has a structure. Second, that entity, it has a plan. It has a plan to commit terrorist acts. Those two elements, if you have one of the two, that's enough to qualify as a terrorist organization. Your Honor, the scholar Todd, mentioned by my colleague in his book, defined what a terrorist organization is.
Is a subnational collective or individuals who pursue a common political goals through the practice of terrorist act.
This writer means that a terrorist organization is a group of individuals pursuing a plan, a political plan to achieve their goals through terrorist acts. Your Honor, honorable judges, different countries and different organizations have clarified the elements that constitute what we call a terrorist organization. In the United States, the UN State Department has classification of terrorist organizations. This is based their basis to qualify an organization as a terrorist organization with the USA Patriot Act of 2001. It says this:
can be placed under terrorist exclusion list if the Secretary of the State finds that the organization commits or incites to commit, under circumstances indicating an intention to cause death or serious bodily injury, a terrorist activity, prepares or plans a terrorist activity, gathers information on a potential target for terrorist activity, or provide material support to further terrorist activity.
This law of the United States of America says this: to qualify as a terrorist organization, that entity needs to be a group of people who commit terrorist acts or inciting other people to commit those acts in a process of preparing, planning, or collecting information to commit terrorist acts, or by supporting logistically or financially a group of people aimed to commit, seeking to commit terrorist acts. So if those elements are met, such a group is considered a terrorist organizations. The United Nations, the European Union, the African Union, Canada, and other countries, and Rwanda have made a list of terrorist organizations. In Rwanda, in the law number 46/2018 of 13 August 2018 about fighting terrorism, in section 41. It provides for how you classify terrorist organizations. For a group, such a group so to qualify as a terrorist organization and be on the list of terrorist organizations, for such a group to be called terrorist organizations, it doesn't have to be on a country so-and-so's list or a list by some organization for that group to be called terrorist organization. What makes them a terrorist organization is that they meet those two elements that make a group a terrorist group. That is being structured, a group that commits terrorist acts, or a group that was formed with the aim to commit terrorist acts. Again, in Rwanda, Your Honor, the different courts, including the High Court and the Supreme Court, have clarified what's required for a group to qualify as a terrorist organization. One example, the case RP 0027/11/High Court Kigali, joined with RP 0036/11 High Court Kigali, and that was tried and at the Supreme Court with RPA 0090/12/CS of 4th of March 2016. In this case, the court clarified what it takes for a group to qualify as a terrorist organization. The court examined if the FDLR was a terrorist organization. The court, based on the activities of the FDLR, based on its activities, it decided that those were terrorist activities because FDLR was a terrorist organization. So the court concluded that based on FDLR's activities, FDLR was a terrorist organization. Your Honor, as we kept mentioning, and the scholars have said this, for a terrorist organization to exist, it doesn't take its being mentioned on a list somewhere. The main thing is that it's committing terrorist acts or it was created to do so. That Todd, the scholar, in his writings said that sometimes terrorist organizations, in their activities, many of those organizations commit different activities that are not just terrorist acts. He says it in these words.
Group diversify their portfolio of attack in order to be less predictable to the authority charged with the counterterrorism activities. Even though most groups use bombing as their primary mode of attack, they also execute armed attack, assassination, kidnapping, and other types of attacks to throw off the authority.
This scholar wanted to show that terror groups do not just do the obvious terror acts. such as bombings. But there are other acts that are different from the obvious, which include assailing people, kidnapping them, and committing other crimes against humanity in fight against the existing government. So if we connect this, Your Honor, with what we have in the case file, we can present to you that there are different acts that were done. They were similar to attacks, such as the attacks in Nyabimata, but there are other acts which were used or which were done, such as bombing in Rusizi, which we will show in the case file. So in some instances, there were attacks to kill people, and in other cases, there were just random bombings to bring terror in the masses. Your Honor, as it is evident in the different scholarly materials that we have presented to you, the different terror groups will often show that they have a just cause. And their reasons are that they are fighting for politics or for change, bringing transformation. But here we find that these terror groups always say that they want to change or they want to fight injustice, but in actual sense, the way they choose to achieve these goals, though they call them just ends, they reach to those ends with terror activities. So when you look at the UN, Your Honor, the decision made by the Security Council of the number 1526, UN Security Council 1566 of 2004, it states,
act including against a civilian committed with the intent to cause death or serious bodily injury, or taking hostage with the purpose to provoke a state of terror in general to public or in a group of persons or particular persons, intimidate a population, or to compel the government or international organization to do or to abstain from doing any act which constitute an offense within the scope of and as defined in the international conventions and the protocol relating to the terrorism, are under no circumstances justifiable by consideration of political, philosophical, ideological, racial, ethnic, religious, or other similar nature.
In this resolution, Your Honor, the Security Council of the UN presented that acts of terrorism committed by terror groups which are based for different gains and they are used with terrorism, they can never be justified, even though they say that they are fighting for a political reason, a religious reason, any other reason they might have, it can never be justified. So here, Your Honor, this resolution showed that whatever you might have in mind, even though it is a good end or a good objective, if you use terrorism, this should be punishable by law. So, Your Honor, we were explaining this in detail to show that in this case file, the acts committed by people, either individually or as a group, they were doing it under a terror group. They did it under FDR and also under MRCD FLN. So we are saying that for as long as these armed groups were established to commit acts of terror, or they committed acts of terror, they'll be called terror groups. In the next part, my colleagues will present that in the following parts of the case, FDR, FOCA, and MRCD are terror groups. Thank you. Thank you. Thank you, Your Honor and Honorable Judges. In actual sense, what I'm about to explain, I will explain it briefly because after my colleagues have explained in detail the meaning of a terror act and a terror group, my work will be brief. We started with a context, and I think they explained it. It was for the purpose for us to understand this before we go into the root causes of this case, that we may understand this. As they have elaborated and they've given the names of the terror groups, and it's for the court to know this, that these terror groups committed terror acts. Your Honor, my colleague has said this. Why are we talking about FDR today? There is no other reason why we're talking about FDR, FOCA. The main reason is that one of the defendants in this case played a major role in acts of terrorism, and these acts, they committed them when they were in the FDR, and there is no other reason, Honorable Judges and Your Honor. So for us to explain in detail about these terror groups and the acts of terrorism, we will use the reports that were done, we will use the survey, and even the other cases that were tried. One of them was mentioned by my colleague. Your Honor, for us to understand FDR, we would start with the role that they have played and their background, starting with the genocide against the Tutsi, Your Honor. There were different groups that were birthed in that time or raised in that time, and these groups were comprised of the youth, young people. There is the group of Interahamwe, which was linked to MRND, the political party, and then there was the group Impuzamugambi, which was connected to the political party CDR. Your Honor, these groups that I've mentioned, the Interahamwe and Impuzamugambi, they had no other objective besides massacring the Tutsis in 1994. But these terror groups, these militia groups, combined with the army of that time, lost the war. They lost to the RPA, Rwanda Patriotic Army. So when they lost to the Rwanda Patriotic Army, Your Honor, these former members of these militia groups and the army of that time fled. They fled with the people, with the population, and they went to Zaire, which is present-day Democratic Republic of Congo. When they reached in the Congo, in the DRC, they didn't do anything else, but they maintained their objective of finishing the genocide, what they started in Rwanda. So they started recruiting again. They recruited people And the people they would recruit, they would give them military training. They recruited child soldiers amongst the refugees. After this, to prove that their cause to return to Rwanda is just, that's when they formed the political party PALIR, People in Arms for the Liberation of Rwanda. Your Honor, when you look at this political party that they formed, they had an army or an armed group. They called it the Army for the Liberation of Rwanda. This armed group had many fighters, and PALIR, it had its headquarters in the Kivu, which was Eastern Congo. All that we have said, Your Honor, we can use the report because it was written in the report that was done by Lakir Omar. Lakir Omar is an activist who works for African rights. Lakir Omar, in 2015, in the report that she gave, she said that these armed groups from Rwanda, after committing the genocide, they reached in the Congo and started recruiting again as human shields, all to meet their political gains and purposes, to return to Rwanda and conclude or finish the genocide that they had started. Again, Your Honor, another basis for this case is the case that took place in Stuttgart in Germany, the case of Murwanashyaka, Ignatius, and Musoni Straton. Your Honor, these two were among the top leaders of FDR. And in that case, Your Honor, it was clear. They explained what PALIR meant, how it was a political party, it had an armed group, and PALIR had a well-organized structure which worked like how ex-FAR or former FAR worked. They had the leader, they had the former army prior to the genocide. Army members were leaders of PALIR. And the objective of PALIR was to return to Rwanda and destabilize the peace in Rwanda and actually remove the government, the new government in Rwanda. So, to describe again more around PALIR, Your Honor, the same plan that they had to destabilize Rwanda, there are acts that they committed here in Rwanda, acts of terror. They attacked in different places. They came this time around called Abashengezi, which means infiltrators. In 1998, they infiltrated. They committed acts of terrorism again in 1998. They wounded people. They killed people. And the people who were killed and wounded in those attacks were innocent. again, we should highlight that they destroyed different infrastructure in Rwanda. Then, again, with the intent that I've just mentioned of destabilizing Rwanda and returning to finish what they started. This was all explained in the report made by African Rights, the African Rights document that we told you about, where the Keir Omar works. She described how the armed group of Palir and Alir attacked different places in Rwanda. And in those attacks, they had targets on prisons, on sectors, commune places, with the same intent as we have mentioned, Your Honor. So briefly, Palihali that I've just explained, when it reached in 1999, Palihali, especially Ali, which was the armed group of Palir, after these terror acts that I've just mentioned, when they would attack Rwanda, the United States of America put Ali on the list of armed groups of terrorism or terrorist armed groups. After some time, Your Honor, there came the second Alir. The first Alir was Palih Alir A. Now then they had Alir 2, or the second chapter. This second Alir was again comprised of ex-FAR soldiers who had fled to the western part of the DRC. Again, this Alir fled to different countries in Sudan and other parts of Africa. But the second one, Your Honor, later worked with a political party which was established called FDLR. FDLR came and worked with the armed group of Alir 2, or the second Alir. So this means we have two political parties and two different armed groups. One is in the eastern Congo, and Alir 2 is in the western Congo. But later, because Alir was put on the list of terror armed groups, the first Alir came to Alir 2, and they decided to join forces, and that's where they birthed FDLR FOCA, or FOCA. Now this FDR, Your Honor, was also mentioned in the report written by Omar. She made it in 2008. And this report expressed how one of the officers of the first Alir, who was also known as Rwara Kabije, sent some officers, where there is Gakara Teofil and Murenzi Sylvestre. He sent them to look for the leadership of Alir 2 to join forces, and that's where they established FDR FOCA. Your Honor, one more point to highlight is this, and this is very crucial. Though FDR is a political party, and FOCA is the armed wing of that political party, it was basically one unit. That's why it's called FDR FOCA. Your Honor, there is a survey that was done. It was done by Nicholas Florken in 2015. He also explained in detail what he discovered from his survey, that FDR and FOCA were just one unit. FDR FOCA has one leadership. It has a hierarchy, it has the top leader, up to the list of the soldiers, but in actual sense, they all lead FDR FOCA. Another thing we can say is that FDR FOCA started attacking in different places on Rwandan soil. People were killed, innocent civilians were killed, infrastructures were destroyed. And we explained this, that all of this that was done based on the explanation that my colleagues gave, these were terror acts. FDR was later put on the list of terror armed groups, and that was in 2012. That was done by the UN Security Council in their consolidated list of terror groups. Another thing we'd like to bring to your attention, Your Honor, is that some of the fighters of the FDR face justice because of these terrorism acts. I can give the example of 30 fighters of FDR who face the justice system here in Rwanda, and the reference of the case, you have it in your file. I will not repeat it. You'll find it on paragraph 50 of the indictment. And FDR didn't engage in these terrorism acts here in Rwanda only, but also in Congo. These terrorism acts, they also committed in Congo. So we can say that there are cases. The case that we mentioned, the case of Murwanashyaka and Musoni, these cases took place in Germany. And there is also the arrest warrant that was done for Mudachumura Sylvestre, who was the leader of FDR FOCA. These cases that we have mentioned took place in the ICC. So, Your Honor, if you permit, I'd like to say that what we're saying is clear, and it's very descriptive of the different acts of terrorism committed in Rwanda and in the DRC committed by this armed terror group. So when they connect this to the explanation given by my this shows that this terror group is armed, and FDR FOCA has been recognized as a terrorist armed group. If you may, I would like to invite my colleague to talk about MRCD FLN. Thank you, Mr. President of the Court. The reason why we keep coming back to these terrorism groups, especially the FDR, as it is explained, and MRCD FLN, the reason why we keep coming back to them, Your Honor, is that the 21 defendants who are before the courts today are being accused of being part of the FDLR, and later they were members of MRCD, and some of them were in MRCD without having gone through FLN. So we had to come back to these terror groups, because all these 21 are linked to the terror acts that they're being accused of, and these acts were committed by these terror groups. So in this case file, Your Honor, there are some that we accuse for being members of the FDR-FOCA. They didn't commit any specific crimes, but they were members, and we'll explain it in upcoming hearings, but they didn't commit any acts of terrorism. They were members, and they worked with the terrorist group. But other acts, criminal acts, they were committed in MRCD FLN. That's why we keep coming back to these two different terror groups. The purpose and the intent of this terror group that keeps coming back in this case file, we keep coming back to it to express the terror acts, the different terror acts committed by each of these terror groups. Now, talking about the MRCD FLN, we have to explain where it came from, where it originated, and frankly speaking, MRCD wasn't far off from FDR-FOCA. When we look at how it was established, Your Honor, as it has been reiterated many times, it has been explained how it all started with PALIR, the political party, which had an armed group called ALIR, which was put on the list of terror groups. There was a strategy to change the name, but the modus operandi was still the same. They just changed the name. It became FDR-FOCA to separate itself from PALIR. It became FDR-FOCA, but it was just a matter of changing names.
The XFAR in the northern Kivu region and the southern Kivu and others further west, closer to Kinshasa and western DRC. But all of those were XFAR. That's what they had in common. They were members of Interahamwe militias. All of them joined within ALIR, but they changed their name to evade sanctions or possible sanctions or being named terrorist organizations because the United States of America had listed them as a terrorist organization. Your Honor, the FDLR, once it came into existence, it did not remain unified as a political organization, because within FDLR itself, some members, especially on the in Europe, they left FDLR, created PDR Humure, PDP Manzi, and other political organizations, including GRDI, Rwanda Nziza, all of them sharing the same agenda as political organizations seeking to overthrow the government in Rwanda. Your Honor, those political organizations that were created elsewhere than the DRC, especially in Europe, had the problem of not having an armed wing. Though they were creating political organizations, they wanted to have an armed wing, but it wasn't an easy task. First, they're in Europe. Second, all the soldiers were with FDLR-FOCA were within the FDLR-FOCA itself. So many started looking for ways to have agreements with other politicians within the FDLR. You know, the politicians within the FDLR had a conflict with the FDLR soldiers. That's you know, Rwanda Shaka cases. And the army commanders. So those, including Pedere Humure and FDI Nyingi with Ngabire Victoire and Pedere of Rusesabagina, they wanted to collaborate with FDLR. It couldn't work out at different stages. And when it failed, they tried to find a way to create armed wings for those specific political groups. FDI Nyingi wanted its own army. Pedere Humure wanted to have its own army. But all of them found that they had to recruit from within the FDLR fighters. They tried that, Your Honor. There was a case with Ngabire Muhoza Victoire. It was established that she was conducting activities to create an armed wing. That trial was concluded at the Supreme Court. It became law. The Pedere Humure of Rusesabagina tried to collaborate with FDLR. It didn't work out. And then it started to recruit from within FDLR ranks and have its own armed wing. Your Honor, in 2009, Paul Rusesabagina he implemented that plan to create his own Pedere Humure armed wing. That's where we will clarify that the background to this dossier of these terrorist acts with Paul Rusesabagina and co-accused. That background is rooted in Burundi. It's not something that started in Rwanda, as some people might think or say, but the background dates from 2009 in Burundi. Your Honor, on 22nd September 2009, the Burundian government arrested two high-ranking officers from the FDLR. Those are Lieutenant Colonel Nyiturende Tarsis, with pseudonyms of Hatari Murindari, and Lieutenant Colonel Murinde Noel, using pseudonyms Bangalambe. Those officers, lieutenant colonels with the FDLR, were battalion commanders within the FDLR, and those were being tested in terms of recruiting from within the FDLR by FDI Nyingi and PDR Humure, with Ngabire Victoire's party and Paul Rusesabagina's political party. They were trying to recruit starting from those. Your Honor, if we may, we'd like to read a letter by by the Director of Intelligence organizations in Burundi in February 2009. That was Major General Adolphe Nshimiyimana. It's in French. I will read it quickly. It's a page and a half. Please allow us to read it. He was writing to the Secretary General of the National Security Services of the Republic of Rwanda, NISS, about Rwandan nationals arrested in Burundi on 22nd September 2009. In the context of the brotherly cooperation between our two services, it's an honor for me to communicate some information related to the two Rwandan nationals, namely Hatari Murinde Henri, in brackets, Nyiturende Tarsis, and Banga Banza in brackets, Habiyaremye Noel, who were arrested in Bujumbura on 22nd September 2009. In the annex, you'll find a note on the facts justifying their arrest and their transfer, a release report and transfer to Rwandan authorities, and a document testifying the money transfer between those individuals and RUSESABAGINA Paul. Please accept our regards and our frank collaboration. And below that, he adds that note referred to. It says this: on 18 September 2009, two Rwandan nationals entered illegally in Burundi, coming from Tanzania. Their intent was to meet with the security official, namely Major General Adolphe Nshimiyimana, to facilitate a political military approach against Rwanda. In spite of their illegal entry, that did not stop them from getting into contact with Major General Adolphe, for whom they had met earlier. So on 18 September 2009, the latter came into contact with Hatari Murinde Henri to seek a meeting with him and his colleague, namely Banga Banza Lambert or Habiyaremye Noel. The meeting of 19 September 2009 by Adolphe Nshimiyimana revealed to him that the two nationals had dangerous intentions against their country, Rwanda, to avoid being found out. Nothing was revealed to them before we arrested them on 22nd September 2009, when the two nationals were transferred to the military authorities in Rwanda. Obviously, phone records between Habiyaremye Noel with RUSESABAGINA Paul for the support in that clandestine mission in Burundi revealed that RUSESABAGINA was the one who was coordinating this. This was revealed through Western Union in Bankobu. The National Intelligence Service in Burundi decided to provide the Rwandan authorities to transfer them the two nationals, Lambert and Noel, because of their intentions to destabilize Rwanda. And other crimes of forgery and other crimes were also mentioned. There was no need for other forms of interrogation to bring them to Burundian justice, because we assumed that the Rwandan institutions would have jurisdiction because crimes were committed by Rwandans and it was about Rwandan security. Your Honor, this letter is the origin of the investigation that started about Paul Rusesabagina's role and that of his colleagues in these acts in this case. These two officers, Lieutenant Colonel Tarsis and Lieutenant Colonel Noel, were brought to Rwanda, and the investigation started, and in the prosecution, and they were accused in a trial all the way to the Supreme Court, which is the case we've mentioned. It was a case, same case with Ingabire Victoire, with the reference RPA 0255/12, Supreme Court of 13 December 2013. And here this Lieutenant Colonel Noel and Tarsis were tried in a high court and the Supreme Court in that case. And when Noel was being interrogated, Noel was interrogated in investigation, prosecution, and at the court, he admitted he collaborated with Paul Rusesabagina. They met through Minani Innocent from Brussels. He clarified that Paul Rusesabagina told him that politics without an armed wing was useless, and he asked him to recruit from the FDLR so they can create their own PDR Humure armed wing. Your Honor, he continued and clarified how he became involved in that trip to Bujumbura, where his colleague, Lieutenant Colonel Tarsis, who was friends with Major General Adolphe Shimimana from the days in the FNL. One was Adolphe was a battalion commander, and Tarsis was the deputy battalion commander, as he explained. He requested for an appointment, but he told his friend Javier Noel, who collaborated with Paul Rusesabagina, told him that that mission was very important because what they wanted was to seek support as military assistance, as explained in that report. So Paul Rusesabagina told him that that's good news. You go ahead and join him. That a golden opportunity, as he explains in those reports that were used, his statements during the investigation and the prosecution and the court. Your Honor, Lieutenant Colonel Noel explained that the capacity, financial capacity to execute that mission was money given by Paul Rusesabagina. In his statement, he explains that Paul Rusesabagina sent them money through Minani Innocent, and they cashed the money in Dar es Salaam. Your Honor, his statement we're talking about a statement from 2009 when he started being investigated. He explained it, but this was confirmed by an investigation in Belgium when the investigation and prosecution in Belgium investigated in the Western Union and confirmed Javier Noel and Iturrinde Tarcis's statement about the Dar es Salaam wire transfer through Western Union. That was the first evidence. You'll see this in an additional evidence in the system, where Belgium investigation clarifies this in these words, in the following words. Following wire transfer to Morinde Atari Henry, a certain Kalume Frank can be confirmed as being his alias, his pseudonym, without pretending to be exhaustive. This reveals that there are 9 wire transfers between those individuals, totaling about $8,809 US, as described in the table below. The transferred amount transferred by Minani to Nyiturende Tarsis was $318,000 withdrawn in Dar es Salaam. Your Honor, obviously, thanks to these Western Union documents, following an investigation by a Belgian investigation, it proves that on 7th September, Minani sent Nyiturende Tarsis, working as under Hatari pseudonym, he sent them $2,138. He cashed it in Dar es Salaam on the 9th. On the same day, he sent $1,079, which he cashed in Dar es Salaam. What we want to say here is that Lieutenant Colonel Noel's statement were confirmed by that evidence from Belgium. Your Honor, based on the investigation, assistance was requested from Belgium. I'm not going to give all the dates. It's in the system already. But Belgium conducted investigations and gave us information and evidence corroborating the evidence as the statement by Habiyaremye Noel. The prosecution also requested assistance from the United States of America, where on 14th January 2011, our prosecution requested assistance in investigation from the United States to know or to establish whether Paul Rusesabagina was the one who sent Lieutenant Colonel Noel, aka Banza-Lambert, the $1,800. And on 4th October 2013, the U.S. Department of Justice sent the Rwandan prosecution a reply, including evidence that based on the investigation in the U.S., it was Paul Rusesabagina who personally sent that $1,870 to Lieutenant Colonel Noel. Habiyaremye Noel had, during the interrogation, had said that that money was sent to him to buy satellite phones that were going to be used in recruiting soldiers from within the FDLR, because they were in the Congo jungle where there was no phone signal. Your Honor, what we just explained proves that the plan to start an army, a PDR Homure armed wing for Paul Rusesabagina, it was a long planned plan. He started to collaborate with the FDLR, didn't work out. And then he opted to recruit from the FDLR, to have his own army. Your Honor, before we continue on to talk more about how MRCD and FLN came to exist as a terrorist organization with a political wing as Pedere Humure. Before we continue, we'd like you to allow us to listen, to hear two context witnesses, and one of them, Your Honor, tell us about the history of Paul Rusesabagina and what he did to collaborate with the FDLR and how he sought financial means using NGOs and foundations and Rusesabagina Foundation, but his real intent was to get funding to help terrorist organizations. That witness used to collaborate with him. So I hope the court will allow us to hear that witness so we can understand how they collaborated. Because witness explains how the person came to meet Paul Rusesabagina through a certain Rubingisa. We have documents in the dossier. We have a statement by Rubingisa that he gave to the Belgian authorities. So this witness used to collaborate with Paul Rusesabagina back in the day, and that person came to learn about how Rusesabagina collaborated with the FDLR, and the witness has a lot of information about this context. Second witness is one of those who was key in trying to recruit from within the FDLR so the PDR can have its own armed wing. That witness is mentioned in the dossier and is the one who is mentioned by that report by the Burundian government. It's a person who tells the truth about the context about these terrorist organizations, be it FDR4K, the birth of MRCD, and then after the witnesses we will continue explaining how MRCD FLN came to be and how it started using an armed wing. So if you allow us, Your Honor, those witnesses are ready. If you allow, the court will hear them.
I'd like to ask that I speak to my colleagues for a few minutes.
Okay, icyo twavuganaga ni
We were discussing on the timing of this hearing. We say that we'll be adjourning at 3 p.m. And you have also brought to light that there is a witness that you would like us to hear. When would the witness come? If the witness is going to delay, it wouldn't be possible. But if the witness is nearby, we can allow them to come in and we hear them, so that we close today at 3 p.m. Thank you, Your Honor. The witness, as I had expressed, is nearby. If you allow, we can actually call them and they come in. And also, on the issue of the timing, we have 2 witnesses, but it's not necessary that we hear all of them today. Where time will lead us, we can have them come in the next hearing. So we'll take a break. No, before we take a break, we'd like to inform the court that the first witness will not witness in Kinyarwanda. So that testimony will be interpreted in Kinyarwanda. The first witness doesn't speak in Kinyarwanda. They speak in English. So let's adjourn, and then we ask that the technical team assist us for interpreting for these. As the witness comes in, we will ask that the interpretation gadgets be given to everyone in the courtroom. The court will also be assisted in this regard, and this will take a few 10 minutes to get us ready for the witness to come, and everything else will come after we come back. So the hearing has been adjourned.
urukiko rurinjiye.
The court. Please be seated.
Okay,
the proceedings will resume now. Prosecution had requested for the court to hear the witness, so please tell them to step forward.
Okay, ariko mbere yuko tugira ibyo tubaza umutangabuhamya ngira ngo abasabwe gusemura baza hano imbere bakarahira mbere yuko bamufasha. Nimba ari umwe nimba ari n'ababiri baza hano imbere. Umwe yakwigira hari mikoro. Hari inyandiko twashize imbere ariko urabanza tubwire umwirondoro wawe. Witwa nde?
Nitwa Jean Claude Mugenzi.
Mugenzi?
Yego.
Ukaba mwene nde?
Ndi mwene Celestin Mugenzi na Mundana Twamugize.
Kawubutse ryari?
Muri 70.
Utuye mu uhe mudugudu?
Ntuye mu mudugudu wa Nonko w'Amahoro muri Nonko muri Nyarugunga ya Kicukiro.
Mirango waje hano niyo mpamvu tugusabye kuza hano imbere ugomba gufasha mu gikorwa cyo gusemura. Ni inshingano itoroshe ngira ngo urabizi. Niyo mpamvu tuza kugusaba kurahira. Wareba nyandiko twashize biteganywa n'ingingo ya 208 twayigushiriye imbere. Ushobora kuzamura ukuboko kw'iburyo ugasoma uvuga amazina yawe isome mu rurimi rworoheye. Hari Ikinyarwanda, Igifaransa n'Icyongereza.
Jewe Jean Claude Mugenzi ndahiriye ko nzakora umurimo nshinzwe ntacyo nirengagije
nkawukora uko ugomba gukorwa nta buhemu, niba ntawukoze uko bikwiye nzabihanirwe n'amategeko.
Urakoze cyane, waha mugenzi wawe nawe yaza. Mwitwa bande?
Nitwa Umuhoza Barbara.
Kaba mwene nde?
Kaba nduyu mukobwa Mfizi Barnabe na Kantengwa Lorette.
Wavutse ryari?
Tariki 22 z'ukwa munani mu 1986.
Utuye he?
Ntuye muri Kagugu muri Gasabo.
Ubwo se niriwe mbabaza ngo mukora iki kubera ko bigaragara ko mukora umurimo wo gusemura. Ngira ngo n'ubundi nimwe mudufasha muri uru rubanza. Ubwo nawe wazamura ukuboko kw'iburyo ugareba iyo ndahiro twashizeho imbere yawe mu rurimi rukoroheye ukarahira.
Jyewe Umuhoza Barbara ndahiriye ko nzakora umurimo nshinzwe ntacyo nirengagije, nkawukora uko ngomba gukora, nkawukora uko ugomba gukorwa nta buhemu, niba ntawukoze uko bikwiye nzabihanirwe n'amategeko.
Murakoze, ngira mwasubiraho mudufasha. Dutegereje ko bagera aho bagomba kudufashiriza. Ngira ko Pene Claude nta kibazo kirimo kugeza ubu.
Nta kibazo kirimo, yarategereje gusa kuza kumenya ko microphones zikora kugira ngo abashe gukurikira ibivugwa mu Kinyarwanda mu gihe bisemerwa mu Cyongereza. Nicyo twategereje ko batangira tukamenya aho ari bushyire.
Sinzi nimba bageze mu myanya yabo badufasha gusobanura. Ngira turumva bisa n'ibyakemutse. Arabyumva? Verisiyo y'Icyongereza irakunda?
Yes.
Ngira ngo tubaze umutangabuhamya yitwa nde, amazina ye?
My name is Dr. Michelle Martin.
Ukora iki? Tubariza akazi akora, ubusanzwe akora iki?
I'm a professor of social work.
Utuye mu kihe gihugu?
United States.
Irango waje hano mutangabuhamya kubera ko ubushinjacyaha bwifuje ko
Yes, I did.
watanga ubuhamya. Urukiko rugira ngo ubaze muri aba bantu bari kuregwa hano hari uwo abamuziranye mufitanye ubushuti cyangwa mukorana yaba ari umuyobozi wawe, wahindukira ukareba ni abaraha.
No.
Naho hari n'undi utitabiriye iburanisha witwa Rusesabagina Paul, we hari ubushuti mufitanye cyangwa yaba ari umuyobozi wawe, uri umukozi we cyangwa we uri umukoresha we, wari umukozi wawe?
I was a volunteer for his organization, Hotel Rwanda RUSESABAGINA Foundation in Chicago, Illinois.
Okay, amfasha umubwira twavuganaga ibyo yaravuze byo gukorana kugira ngo turebe niba tuza kumwumva nk'umutanga buhamya. Nicyo twarimo tuvugana hano, ariko twasanze nta kibazo. Ariko banadufashe ngira ngo tradiction ku ruhande rw'urukiko isa naho itari kugenda neza, n'abagenzi banjye nanjye ubwanjye dufite icyo kibazo. Ubwo uraza kuzamura ukuboko amufashe, hari inyandiko twateguyeho irindahiro, uyidusomera uvuga amazina yawe noneho dusomera iyo ndahiro. Zamura ukuboko usome iyo ndahiro.
I, Michelle Martin, swear to tell the truth. Should I fail to honor this oath, may I face the rigors of the law.
Murakoze cyane. Ngira ngo turaza kugusaba kugerageza kuvuga gahoro witonze, nako kubera dufite umwanditsi dukeneye kwandika ibyo uze kutubwira. Watangira ukaduha ubuhamya bwawe burebana n'iyo context.
Okay. Again, I'm a U.S. citizen. I'm here voluntarily to provide my testimony in these proceedings. My testimony is truthful and accurate and based on my own personal observations and experiences. I would like to share a little bit about my background information. I have a PhD in peace studies and international development from the University of Bradford in the United Kingdom, a Master of Social Sciences in Global Policy Studies from the University of Bristol, also in the United Kingdom, a Master of Social Work from the University of Illinois at Chicago, and a Bachelor of Arts in Psychology from San Diego State University in San Diego, California. I am currently a professor of social work at California State University, Fullerton. I'd like to share why I'm here today. I have information that I learned beginning over 10 years ago that relates to this case and that I have agreed to share with the court. The information relates to my personal knowledge of the activities of Paul Rusesabagina and his associates with PDR Ihumera and their allies. I learned some of this information through my professional association with an individual named Providence Rubengisa, a friend and colleague of Paul Rusesabagina, as well as my direct experiences with Paul Rusesabagina and his organization, the Hotel Rwanda Rusesabagina Foundation, in the general time frame of the fall of 2009 and about September of 2012. I want to mention that I did write out my testimony because it is very complicated. The information that I have came from numerous sources, and there's a lot of documentation, and I want to be very clear and precise. I also want to mention that a lot of the information I uncovered relates very much to the person that I am as an academic and as a researcher. I have a natural curiosity, and if something captures my attention, I will stick with it until I figure it out. But I am not here in any sort of professional capacity, and nothing that I did related to uncovering this information was related to my professional career. I also wanted to mention about how I preserved information that I'm drawing on today in my testimony. Something else about my personality or the way I approach life is I keep pretty much everything related to technology, including taking short screenshots on my MacBook if I'm curious about something or suspicious. I send emails to myself. I like screenshots because it creates a timestamp, so I remember. In relationship to what I'm going to share with you today, I still have all of my emails and text messages and screenshots. And in fact, in preparing for today's testimony, I reviewed hundreds of old emails, text messages, screenshots of emails and text messages, notes I wrote to myself, emails I wrote to myself, and I still have all of that in my possession, both on my laptop as well as in a password-protected cloud service. I'm going to begin my testimony by sharing how I met a founding member of PDR Ihumera and an associate of Paul Rusesabagina. In the fall of 2009, I was a member of the faculty at a university in the Chicago area called Dominican University. I was on the social work faculty there, and in my first year, I was asked to facilitate a series of workshops on immigrants and refugees. I reached out to a friend and colleague who worked with a refugee resettlement agency in my area, and I asked if he had any recommendations for speakers. And he told me that he was well acquainted with someone who was a genocide survivor and had a story, an incredible story of survival and heroism. And that was Providence Rubengisa. I invited him to be the first keynote speaker of the conference, of the first conference, in the fall of 2009. He told a story that I found very touching and impressive. He told a story of how he was a genocide survivor and how he rescued numerous Tutsi during the genocide. But he shared that he was of mixed cultural heritage or ethnic heritage, which he claimed placed him at increased risk in Rwanda. So therefore, in the early 2000s, he needed to flee. And he fled to the United States. I was so impressed with his story, including his story about his humanitarian organization called Stuff for the Poor. I was so impressed that I offered to help him with his charity. And he took me up on that offer. During this time, which was approximately 2009 through 2010, I provided a considerable amount of support, both conceptual and concrete, for his charity. I'm now going to share how I gained access to Providence Rubengisa's email account. Because Mr. Rubengisa was not completely fluent in English, he asked me to write most of his correspondence. On several occasions, he shared his email password with me via text message and email, and I still have copies of those communications. Initially, he asked me to access his email account to respond to specific emails. He was looking for previous donors to his charity. The nature of his charity, as he explained during the conference, was that he had local churches and schools donate used shoes, which he claimed he shipped to Rwanda to give to widows and orphans. This touched many Americans, and he was very successful at what he called shoe drives. So what he wanted me to do initially was go through his email and find past donors and send them emails so that we could have new shoe drives. So as I said in the beginning, he would ask me specifically, please go into my email and answer these emails. But eventually, he just started saying things like, you already have my password, just go in and handle that. And I would. The first time he asked me to access his email account was the fall of 2009, shortly after we met. And the last time was on September 8th of 2012. And that was in response to someone in another country related to a political issue. So in the beginning, again, it was related to his charity, but as time went on, he relied on me to answer a lot of emails. I now want to talk about other assistance I provided Mr. Rubengisa, including allowing him to use my home office for long conference calls with other Rwandan exiles. Those were typically held on Skype, audio, and those calls were led by Paul RUSESABAGINA. The calls, I later learned, focused on a number of political issues. But during that time, a lot of the calls related to PDR Ihumera's support of PS Imbonerakure. Most of the time, I mentioned before, these calls were on Skype. They would last for hours. They were in Kinyarwanda. He explained that the calls were facilitated by Paul RUSESABAGINA, and that's when he told me he was part of a political opposition group called PDR Ihumera. He described how the leaders of PDR Ihumera had asked Paul RUSESABAGINA to be the president of the party because he got so famous after the movie Hotel Rwanda. He told me they were supporting an opposition candidate, Bernard Ntaganda, who was the head of PS Imbonerakure. I remember that Mr. Rubengisa explained on several occasions in late 2009 and early 2010 that his organization, PDR Ihumera, helped create PS Imbonerakure. And I specifically recall him sharing with me that PDR Ihumera's plan was to support Bernard Ntaganda, whom Mr. Rubengisa knew from school, in running against President Paul Kagame in the 2010 Rwandan presidential election. He said their plan was that once Ntaganda was elected, Paul RUSESABAGINA would return to Rwanda and assume the role of president, which was an arrangement that Mr. Rubengisa claimed was agreed to by Ntaganda. I recall that on at least 2 occasions, after lengthy conference calls with Paul RUSESABAGINA and several other PDR Ihumera members, that Mr. Rubengisa expressed frustration about Paul RUSESABAGINA, because he did not believe that he was providing sufficient financial support to PS Imbonerakure. I also recall Mr. Rubengisa telling me that no one could know about Paul RUSESABAGINA's political ambitions because he was supposed to be just a humanitarian. In approximately January of 2010, Mr. Rubengisa asked if I would help Bernard Ntaganda write his political platform. He wanted it written in a way that would appeal to Western audiences. I'm a writer, an author. He also wanted me to help Mr. Ntaganda obtain a visitor visa by inviting him to speak at my university. But he then explained to me that Mr. Ntaganda would likely only visit Washington, D.C., and not Chicago. I did communicate with Bernard Ntaganda via email, and I did help him edit his political platform, but I did not provide assistance in helping him obtain a visitor visa. I still have those email communications in my email account. I'm now going to talk about Yahoo News Group posts that Providence Rubengisa forwarded to me from shortly after we met through early 2013. The posts were contained in emails from several Yahoo news groups managed primarily by PDR Ihumera members. I still have approximately 170 of these Yahoo news group posts in my possession. I have them in PDF format, and I also have many of them in their original format. These posts contained primarily political content about Rwanda. They often had links to news articles, press releases, and other content. And they often included discussions and commentary by group members who were PDR Ihumera members. In fact, many of the news group postings were disseminated as emails, as I mentioned, and they had a trail of previous discussions, sometimes extending back months. And I got into the habit of scrolling down to the bottom and attempting to read through the entire thread. I do not speak Kinyarwanda, but many of the discussions were written with French and English interspersed throughout. Thus, I could often get a general sense of what was being discussed. While I initially did this out of sheer curiosity, in time, I began to read the discussion chains because I had a growing suspicion about this US-based group and its members. At some point, I figured out that I could use Google Translate, selecting Swahili as the original language. At that time, Kinyarwanda was not included in that platform, and that was generally useful for understanding the meaning of the discussions. I was previously aware that some political opposition groups were advocating for change in Rwanda, and I supported this within the vein of an open and free democracy. For this reason, in the very beginning, I was not concerned about the content. I'm now going to share my slowly growing concerns at that time about the news group postings that also coincided with my growing concerns from other sources. I mentioned earlier that from about 2009 to May of 2010, based on the information Providence Rubengisa was sending me, I was becoming convinced that there was an alternate narrative of the Rwandan genocide that no one else knew. And what I mean by that is no other Westerners knew. But in time, I became increasingly disturbed by the content and the bulk of the posts and emails, which were again highly political, with many posts having content reflecting what I later recognized as Hutu power ideology, including the denial of a Tutsi genocide. For example, in one news group posting that included an article of a genocide commemoration in Ottawa, Canada, with a photograph of Tutsi genocide survivors crying. The author of the post, a member of PDR Ihumera, wrote, quote, "Are they crying or faking?" Other posts included articles and commentary on the FDLR and Habyarimana. And the comments on these posts were consistently and overwhelmingly supportive in nature. Essentially, my perspective after several months of reading, as well as other observations I will describe shortly, was that many of the newsgroup discussions and other emails forwarded to me by Mr. Rubengisa and others, again, reflected strong anti-Tutsi sentiments. What I later discovered as overt genocide denial, and a clearly orchestrated plan to take their country back by any means possible. I'm now going to share information about media stories and other articles Providence Rubengisa shared with me about himself and other PDR Ihumera members, and what I eventually came to believe was intentional misleading of the American public. From approximately fall of 2009 through 2011 or 2012, Mr. Rubengisa was also forwarding to me various news articles about himself and, as I mentioned, other members of PDR Ihumera. And in these articles, they identified themselves as genocide survivors, working to support those remaining in their home country of Rwanda. I also noted that many of the PDR Ihumera members who spoke with the media provided what I believed were purposely misleading narratives. For instance, some very active members of PDR Ihumera who self-identified as Hutu in the Yahoo news groups would often identify themselves as Tutsi genocide survivors to Westerners. Others just identified themselves as genocide survivors and then provided conflicting narratives in media reports. It eventually became obvious to me that they knew Americans believed that quote-unquote genocide survivor meant that they were Tutsi. And I believe their attempts to confuse narratives was purposeful. For instance, they might share stories that were completely consistent with what happened to Tutsis during the genocide. Being stopped at roadblocks, being asked for their ethnic identity cards, having their lives threatened. But then the stories would take what seemed to me to be a false turn. The Interahamwe would let them go. And then they would escape into Zaire and live in the refugee camps along the border. Again, these statements appeared to me to be purposeful attempts to confuse the American public with conflicting narratives of the genocide and ethnic identities. I knew that some moderate Hutus were targeted and killed during the genocide, but I was unaware of any instances of Hutus being threatened with death after showing an ethnic identity card at a roadblock. Additionally, based on my research, I learned that most Tutsis did not flee Rwanda after the genocide, and those who fled during the genocide did so through oftentimes Burundi, but not Zaire. It made no sense to me that Tutsis would flee persecution after the genocide by following the path of over 2 million Hutus into exile into the Congo, many of whom were allied with the former regime and some of whom were genocidaires. I kept these media articles, many of them, and have included them with the other documents I've provided to the Prosecutor General. Other things I observed during this time that made me suspicious included seeing the Facebook posts of some PDR Ihumera members who sent me friend requests. For instance, some had photographs posted in their Facebook photo albums that included FAR identification cards, as well as other identifying information, such as their old ethnic identity cards. And the names on them oftentimes did not match the names they were using in the United States. For instance, their ethnic identity card would oftentimes say they were Hutu, but they would self-identify as Tutsi or mixed. Additionally, throughout the newsgroup postings and other email communication, PDR Ihumera members and many of their American allies would frequently refer to the genocide as the so-called genocide. Or they referred only to a Tutsi genocide against the Hutu. I might not have recognized this alternate narrative as being false, and in fact, as I previously mentioned, at first I didn't. But the research I was reading at the time in preparation for my dissertation informed my thinking. I read everything I could on the region and the genocide, including books, scholarly articles, and studies and numerous reports from a range of experts with a range of perspectives. I'm now going to talk about being asked to write Providence Rubengisa's autobiography. I mentioned earlier that I'm an author. I have 3 books out, nonfiction, textbooks, and other publications. For several months during 2009 and 2010, Providence Rubengisa and I met regularly, and I interviewed him, writing notes of our sessions, which I still have in my possession. I interviewed him because he asked me to write his autobiography, so I was interviewing him as a ghostwriter. In our early interviews, Mr. Rubengisa shared the traditional narrative of the genocide, that extremist Hutus killed Tutsis and moderate Hutus. He also claimed that he was just as much of a hero as Paul Rusesabagina, because he too rescued Tutsi. In time, though, a conflicting narrative emerged, both within the interviews as well as in our general discussions. And that was a narrative that was more consistent with the newsgroup postings he was sending me. During the interviews and other discussions, he told me there was a story about Rwanda no one knew. He then shared that there was actually a double genocide. He stated that for every Tutsi who was killed, 1 or 2 Hutu were also killed. He initially told me that he was mixed, culturally or ethnically, which would give him an advantage in understanding the ethnic conflict in Rwanda, but as I mentioned earlier, also put him at risk in Rwanda and was one of the reasons he needed to flee. But later in our interviews, as well as in other discussions, he contradicted himself, stating that both of his parents were Hutu, but that his dad and sisters looked Tutsi because they had quote-unquote thin noses and were tall and thin. He also provided several names of friends and colleagues who helped rescue his Tutsi-looking sisters and kept him safe during the genocide. At some point, I became curious enough to start searching through ICTR records, and I found several of the names Mr. Rubengisa had referenced with the associated locations listed as being members of the Interahamwe. And I believe they are the same individuals to which Mr. Rubengisa was referring. For example, when Mr. Rubengisa was telling me about the night that former President Javier Amana's plane was shot down, he told me that he was watching a soccer game with a very good friend, Eugene Karekezi, Karekezi. I later found an ICTR judgment and sentence transcript online that referenced someone with that same name who lived in the same region, referenced by Mr. Rubengisa as being a high-ranking member of the Interahamwe. And that was in the case of Andre, Ntagerura, and 2 other people, and that was ICTR 9946T. Mr. Rubengisa also shared background information leading up to the genocide, including that all Tutsi families were harboring, quote-unquote, RPF infiltrators, and that the RPF was killing Tutsis and then blaming it on the Hutus. I later learned that this narrative was completely consistent with the pre-genocide propaganda campaign disseminated on government-controlled radio and print media. Mr. Rubengisa also shared stories with me about someone he referred to as a good friend named Lieutenant Bizumuremya. I'm sorry, Bizumuremyi, who Mr. Rubengisa explained was sent to Gisenyi from Kigali. Mr. Rubengisa stated that he initially met the lieutenant in Kigali through mutual friends, but during the genocide, the lieutenant was staying at the Meridian Hotel in Gisenyi, which is where Mr. Rubengisa was staying. And he saw him, and they began spending a lot of time together and became much better friends. He even told me that he used to allow the lieutenant to use his room for visits with a female companion. He explained that it was the lieutenant who helped him rescue his sisters from Kigali. One of the books I was reading at the time was Linda Melvern's book, Conspiracy to Murder. In her book, Melvern describes the role of Lieutenant Bizumuremya, the role he played in the genocide, including instructing civilian Hutus to, quote, spare no one, not even babies, close quote. And yet Mr. Rubengisa described him to me as a hero. While describing his trip from Gisenyi to Gitarama to rescue his sisters, Mr. Rubengisa described a good friend of his named Omar, who was with the Interahamwe and manned a major roadblock in Gisenyi, and he shared how Omar helped him get through the roadblock without harm so he could safely leave Gisenyi. When I asked why he was friends with someone in the Interahamwe, he explained that he told Omar that he shouldn't be killing Tutsis, but only the RPF, and that Omar agreed. But I later conducted a Google search on Omar, Interahamwe, and Gisenyi, and I found an ITCR statement of someone by the name of Omar Sarashagu. SERUCHAGO, who was an Interahamwe member, who actively participated in the genocide, and who carried out the orders of Anatole NSENGIYUMVA. I believe that Omar Sarushago is the same Omar referenced by Mr. Rubengisa, due to many similarities, including Omar's location as being Gisenyi, Omar's role in manning a major roadblock in Gisenyi, and a reference in his ICTR statement to having worked with the lieutenant. Additionally, during one of our interviews, Mr. Rubengisa shared that it was government military who helped him and his sisters get through the roadblocks and who made arrangements for them to stay at the Bagogwe, B-A-G-O-G-W-E camp, which he described as being 30 miles from the Meridian Hotel. When I read Sarushago's ICTR statement, he stated in there that the Bagogwe camp was an Interahamwe military training camp. Mr. Rubengisa also told me that he had been invited by the ICTR defense attorney to testify on behalf of Matthew, M-A-T-H-I-E-U, he called him Matt, N-G-I-R-U-M-P-A-T-S-E, in Arusha. Other disclosures made by Mr. Rubengisa during my interviews with him included that he, and these are in quotes, had no problem with the Habyarimana government, that there was, quote, no ill treatment of the Tutsi prior to the genocide, that the, quote, RPF invaded Rwanda and Tutsi were killed because most Tutsi were affiliated with the RPF, close quote, that he believed, quote, more Hutus died than Tutsi, close quote, that there was no genocide, but rather there was a, quote, civil war with civilian casualties, close quote. All of this information ultimately led me to question who Mr. Rubengisa really was. Was he a genocide survivor who rescued Tutsis, or was he an extremist Hutu and member of or closely tied to the Interahamwe? I remained stoic during these interviews and at no time revealed what I believed I was discovering. I'm now going to talk about what I learned about Providence Rubengisa's arrival to the United States and the formation of his nonprofit charities. During many of my discussions with Mr. Rubengisa, I also learned that he moved to Romeoville, R-O-M-E-O-V-I-L-L-E, a Chicago suburb, in approximately 2003, and lived with Jean-Marie Vianney, V-I-A-N-N-E-Y. And the last name I'll spell is M-U-D-A-H-I-N-Y-U-K-A, but he went by the name of Zuzu. Sorry. He was a high-ranking member, I later learned, of Interahamwe. Providence didn't want anyone to know because he said they would not understand. He also told me that Zuzu, who was arrested in 2004 on charges of genocide and then later deported to Rwanda in 2011, was innocent and was only arrested because he was being unfairly targeted by Kagame. He also told me that he had met an American who lived across the street from Zuzu at the local library. He explained that he told her that he was a genocide survivor and that he had no place to live. She introduced him to her husband, and they let him move in with them with their children. And together they started a charity called Global Family Rescue, also going by the initials GFR. Mr. Rubengisa explained that GFR sponsored families in Rwanda through fundraising in the United States, primarily from churches and schools. And Mr. Rubengisa got Paul Rusesabagina involved with GFR, which I'll explain later in my testimony. Mr. Rubengisa also told me that he started attending a local community church with the American couple he lived with, and through them met other Christians who wanted to help him. One woman ended up introducing him to friends of hers who were very involved in American politics, and together they started the Hotel Rwanda Rusesabagina Foundation. In my testimony, I either refer to that as HRRF or the foundation, and that was created in 2006. According to my personal notes, which I still have, Mr. Rubengisa shared that he and Paul Rusesabagina were involved in both charities, but GFR was more Providence's, and Hotel Rwanda Rusesabagina Foundation was more Paul Rusesabagina's. Mr. Rubengisa also shared that at one point in time, HRRF was concerned that they weren't doing enough humanitarian work. And I believe this concern came from someone accusing them of being a political organization. So according to Mr. Rubengisa, Paul agreed to award a $60,000 grant to GFR. Per Mr. Rubengisa, GFR was doing very well in Rwanda, sponsoring families in need, but was then investigated by the Rwandan government and was subsequently shut down. Mr. Rubengisa believed that this was because Paul Rusesabagina was involved. I deduced later from reading various emails that I will describe later in my testimony that many of the families sponsored by GFR were actually Mr. Rubengisa's family members and close friends. I also strongly believe that various projects Mr. Rubengisa fundraised for under the guise of helping widows and orphans in Rwanda were actually his personal projects in Tanzania and Rwanda. Once Mr. Rubengisa knew that GFR would not be able to continue working in Rwanda, they actually ended up moving to Uganda. He and the other American woman he met through his host family immediately started his charity Stuff for the Poor. I'm now going to talk about how I met Paul Rusesabagina and became a volunteer at Hotel Rwanda Rusesabagina Foundation. Prior to when I started having suspicions, and in around the fall of 2009, Mr. Rubengisa offered to introduce me to Paul Rusesabagina, stating that they had been good friends in Rwanda. I was very excited because I had seen the movie Hotel Rwanda, and I believed he was a hero. I believe it was in approximately October of 2009 that I met Paul Rusesabagina at a restaurant in Chicago for dinner. And during dinner, he discussed his role in the 1994 genocide and his humanitarian organization, Hotel Rwanda RUSESABAGINA Foundation in Chicago, Illinois. He asked me if I'd be interested in working at Hotel Rwanda RUSESABAGINA Foundation as a policy advisor on a volunteer basis, and I enthusiastically agreed. I began working at the foundation shortly thereafter. I volunteered with the foundation for much of 2010, and my work was primarily on the policy team with another American academic. Paul ended up writing me a letter of support for my faculty position and my contract renewal. And in that letter, he accurately described my volunteer role as conducting a, quote, comprehensive policy review, critically analyzing the Rwandan Constitution and other government functions and activities in order to highlight institutionalized forms of human rights abuses under the Kagame administration, as well as other supportive activities, close quote. An example of other activities was locating articles on the upcoming presidential election. I also attended several of Paul's speeches and foundation meetings. Additionally, I placed a graduate social work student from my university at the foundation as an MSW, so Master's of Social Work, intern, and she worked there from approximately January of 2010 to May of 2010. During my initial dinner with Paul RUSESABAGINA, as well as during all foundation meetings where he was in attendance, as well as during various speeches, including one at the Chicago Holocaust Museum, Paul RUSESABAGINA recited a narrative of the genocide that closely matched the Hotel Rwanda movie. Again, that the extremist Hutu government orchestrated the mass killings of Tutsis and moderate Hutus, and that he, RUSESABAGINA, protected Tutsis at the Hotel de Milcolin from extremist Hutus in the Interahamwe. Paul RUSESABAGINA also spoke about the importance of his humanitarian work and his foundation and his commitment to those he left behind. I recall during one foundation meeting in Chicago, I believe that was on February 15, 2010, because I took notes. And Paul RUSESABAGINA was in attendance at that meeting. The subject came up about accusations of the former Rwandan ambassador to the United States, James Kimonyo, who had accused Paul RUSESABAGINA of collaborating with the FDLR. The Americans in attendance laughed at the absurdity of the accusations, and Paul joined in, referencing how funny it was that Kimonyo was accusing him of something so preposterous. He then used these accusations as an example of just how far Kagame would go to harm him, and I recall at that time feeling outrage that his reputation was being harmed in this way. Another issue I recall being discussed by both Paul RUSESABAGINA and the American leaders of Hotel Rwanda RUSESABAGINA Foundation were the conditions in Rwanda at that time. At the meeting on February 15, 2010, Paul spoke in detail about how the streets in Kigali were empty because everyone was too frightened to be out in the community, stating something about how this information was coming from his contacts on the ground, who were reporting that people were so frightened to leave their homes, that they were starving, and I have in parentheses in my notes, or were not permitted to, that they were starving in their homes. And Paul RUSESABAGINA and the foundation were working with human rights organizations to try to get people food throughout Kigali. Around the same time period, which was about spring of 2010, my student intern forwarded a document to me via email that one of the American leaders of the foundation had authored, and emailed to her when she told him that a friend of hers was planning a trip to Rwanda. In my former student's email to me, she wrote, quote, "He advised that my friend should review this document and consider asking these questions and then report back to the foundation on what her experiences were on her trip," close quote. The document was entitled "Questions to Ask When Visiting Rwanda." And the title on the first page of the document was, quote, "Visiting Rwanda, things to consider and questions to ask when you arrive behind the banana beer curtain." The first part of the document compared Rwanda to Soviet satellite states during the Cold War, with the Rwandan military controlling the perceptions of all visitors. The document introduces the reader to the, quote, corruption of the Tutsi-led government, including the government's one-sided genocide narrative that the genocide was only against the Tutsi, including how visitors were compelled to visit a genocide memorial as a form of indoctrination. The document is then organized by issues and includes recommended questions relating to each issue. The first issue was language, and the author notes that it is now considered taboo in Rwanda to ask any Rwandan what their ethnic group was, but it cites various quote-unquote clues about who is Tutsi, alleging that it is only Tutsis from Uganda who speak English, whereas, quote, uneducated Hutus, close quote, speak primarily Kinyarwanda. The document also asserts that friendly Rwandans that tourists meet are likely members of the RPF. The next issue is the 1994 genocide. And the author recommends that if that subject arises, the traveler should ask why Hutus do not qualify for any genocide survivor program benefits, as well as asking tour guides if survivors mind seeing their desecrated remains of their family members at the genocide memorials. The next issue is education, and the author encourages tourists to visit a school or university and ask about genocide ideology and how that applies to students and teachers. The author goes on to explain that, quote-unquote, genocide ideology is a term used by the government to describe anyone who disagrees with the official view of the genocide, that Tutsis were the only victims. Other questions relate to solidarity camps, the exclusion of Hutu children from public education, and also what history lessons are taught in schools. Other assertions include referring to Rwandan local defense forces in rural areas as local militias, organized by the government to limit dissent against the quote-unquote regime. The document also refers to Tutsis as government elites and said that they should be asked the quote-unquote hard questions. At that point, I had no reason to question the assertions that the streets of Kigali were empty and people were starving in their homes. But I do recall feeling as though the questions were very ethnocentric, in that they were highly intrusive, reflected a strong Western bias, and appeared designed to catch Rwandans lying about their country. Even if the allegations in the document were accurate, I still believe that the questions were highly inflammatory and inappropriate. When I finally had the opportunity to visit Rwanda, to attend a conference and visit a university internship site, I was struck by the stark differences between what I was told by Paul RUSESABAGINA and the American leaders of Hotel Rwanda RUSESABAGINA Foundation and what I experienced during my trip. People were out and about, mingling, shopping, eating out, and talking seemingly freely. And it really struck me then just how damaging this propaganda was to the people of Rwanda, as well as potential visitors from the United States. And I perceived the content, eventually perceived the content of the criticism to be a form of genocide denial. At another Hotel Rwanda RUSESABAGINA meeting that I attended on September 21st, 2010, an American student from a Chicago university was present and shared her experiences visiting Rwanda through a study abroad program. The student mentioned being, quote unquote, fully briefed by one of the American leaders of the foundation before she traveled to Rwanda. And some of the quotes, some of the things she said, I wrote down exactly, and I'll read them. Quote, "If I didn't know all of this was going on in Rwanda, if I was a regular tourist, I would have no idea. Everyone is outside, walking around like nothing is wrong." Quote, "The genocide memorial was very emotional. I had to remind myself of the truth when I left the memorial." And quote, "They no longer have genocide survivors conducting tours at the genocide memorials because they would tell their personal stories, and that could lead to questioning about the story and the ability of people to question about whether Hutus got killed too. So now the government only wants English-speaking government tour guides to tell the government's version of the genocide." Quote, "All spokespersons in Rwanda are RPF." Quote, "The homestays coordinator for the students was a government agent and placed students only with Tutsi elites. When I asked her how she knew this, she stated, quote, 'Well, of course, why wouldn't they be?' She also shared that the family she stayed with accused her of genocide ideology because she challenged them on their story of the genocide. She stated that her host, father, was in technology, which convinced her that all of her emails were being monitored. She also talked about visiting refugee camps in Uganda, stating she was certain all of the refugees were Hutu. And when she interviewed the refugees, they apparently stated that they were, quote, 'waiting to go back and take back our country,' close quote. Again, I recognize all of this later as genocide denial. I now want to talk about a curious pattern I noticed during the time period of March 2010 to April 2010 among everyone involved in the Hotel Rwanda RUSESABAGINA Foundation, the Foundation's American allies, and members of PDR Ihumera. This pattern emerged for me both in discussions with them as well as in the emails I was reading. No one associated with Hotel Rwanda Rusesabagina Foundation or PDR Ihumera seemed to believe that any Hutu accused of genocide was guilty. Rather, each incident of someone being arrested for genocide seemed to serve as an example of Kagame seeking revenge for political purposes and targeting Hutu intellectuals. One example that stood out for me involved a Rwandan exile in Dayton, Ohio. She reached out to me through Facebook on March 1st, 2010, to ask for my help in finding an attorney for her political asylum case. I had my role at the foundation on my Facebook page and was friends with several people affiliated with the foundation and PDR Ihumera. And I believe this woman reached out to me as a representative of the foundation. I still have these messages in my possession, as well as notes I wrote myself with my thoughts and concerns in regard to the situation and the foundation's response. The woman wrote that she came to the United States on a conference visa and learned just prior to her planned departure back to Rwanda that she had been charged in Gacaca for collecting names at a Pentecostal church in NYABISINDU during the genocide, and providing that list and providing a list of those names to the senior pastor, who in turn was accused of passing them on to the Interahamwe. She denied the charges, stating that the names were collected for the purposes of obtaining food from the Red Cross. I asked her to email me a statement of what she had shared with me in our messages so that I could forward her information to the foundation leaders and Paul Rusesabagina and 2 American attorneys who worked with the foundation and defended many Rwandan exiles charged with genocide. At around the same time, another Rwandan exile from the Boston area had also reached out to me asking for help and support from the foundation because she had been charged by U.S. immigration officials with lying on her political asylum application in relation to the 1994 genocide. She asserted her innocence and told me that she and her family members were genocide survivors and had sought refuge in Rwanda from extremist Hutus, just like everyone else. I referenced this woman's case as well in my email to the foundation leaders and the attorneys. One of the American leaders of Hotel Rwanda Rusesabagina Foundation responded, stating, quote, "As I said in an earlier email, we can devise a letter to our contacts at Homeland Security about the general issues that are facing Rwandan refugees and the political nature of the Gacaca courts and other charges against people recently to try to help them understand the political climate that people are fleeing, period. But what else should we be doing? I feel like," and then she referenced the names, 3 names, "are the tip of the iceberg, and that we need to get prepared because the iceberg is melting and the wave is coming straight at us." Close quote. On April 11th, 2010, the American attorney responded again, asking if the foundation could provide financial support for the Rwandan exile in Dayton so she could have an attorney represent her at an upcoming hearing, stating that he was willing to serve as an expert witness in her case, as he had with other Rwandan exiles charged with genocide-related crimes, because his conscience would not allow him to do nothing while the U.S. government sent innocent refugees back to Rwanda. He concluded by stating, quote, "Actually, all caps, we are now in the same position Paul was in at the Mill Colleen. If people are going to get saved from Kagame, we have to do it." Of course, that was then, this is now, and that was him, all caps, and this is us, all caps, exclamation point, close quote. At some point later, when I recognized this collective response to genocide accusations among the Foundation staff, Paul RUSESABAGINA, and other PDR Ihumera members, I Googled the details the Rwandan exile in Dayton had shared with me about her case, and I found a news article that I was confident referenced the church where she had stayed, and it was a Pentecostal church in NYABISINDU, where 560 Tutsis were slaughtered, and at that time the remains had still not been found. After reading the story, I reached out to the woman and asked if she had at all been suspicious about why she was asked to collect names of only Tutsis, since the Interahamwe had surrounded the church. And that was according to media reports, but also her statements to me. And she replied, quote, "No, I never looked out the window." I found this very suspicious. She had already told me that the Interahamwe were out there and that they kept coming into the church and taking Tutsis out to kill them. So her answer made no sense to me. I subsequently learned that the Rwandan exile in Boston and her sister, who had also been charged by U.S. immigration officials, had in fact been involved in the genocide in relation to a roadblock in Butere in front of a family-owned hotel. The details of the family's involvement were absolutely horrifying. Yet both of these women had identified themselves as traumatized genocide survivors who hid during the genocide within their communities. They said this in their communities to the media and to me. And one was even writing a book about her story. Again, what I found odd was that none of the individuals on the email chain ever questioned whether any of these individuals charged with genocide-related crimes were potentially guilty. I'd like to now share some information about growing concerns both I and my student intern had about the nature of Hotel Rwanda RUSESABAGINA Foundation and the type of work they were doing. Within a few months of working with the foundation, both my student intern and I had come to believe, based on our observations, the foundation did not operate as a humanitarian organization at all. Rather, it operated as a political organization with the apparent primary goal of overthrowing the Rwandan government. I knew that in the United States, an organization that is registered with the Internal Revenue Service, what we call a 501c3, is barred from engaging in political activities, including lobbying, which the IRS defines as contacting decision makers about legislation and asking for support one way or another. Hotel Rwanda RUSESABAGINA Foundation was registered as a nonprofit, non-political charity providing, quote, human services, close quote, focusing on, quote, human rights, basic and emergency aid, and international development, serving children and youth, women and girls, low-income people, and victims of conflict and war. And that information is public, and anyone can look it up on the internet. Between approximately March to May of 2010, my student regularly reported to me her discomfort with the nature of the foundation and its singular focus on Rwandan politics and the lack of any humanitarian work. As social workers, we were very familiar with how humanitarian organizations operated in the United States. And it was our observation that the foundation activities were inconsistent with a non-political humanitarian foundation. For instance, Hotel Rwanda Rusesabagina's foundation mission statement read in part to, quote, improve the lives of victims left orphaned and widowed by the various killing fields in our world's history, close quote. And yet neither I nor my intern observed any activities that focused on widows and orphans during the several months we were associated with the organization. Again, the primary focus of Hotel Rwanda Rusesabagina Foundation and Paul Rusesabagina appeared to be solely on removing President Kagame from power. When an American attorney was arrested in Rwanda in late May 2010, and this was an attorney that was closely affiliated with Hotel Rwanda Rusesabagina Foundation, my intern contacted me with significant concerns because leaders of the foundation were asking staff and interns to lobby U.S. government officials for his release, something my intern believed was inconsistent with the role of a non-political humanitarian organization and her role as a social work intern. I'm now going to talk about how I learned about the extent of the political pressure the Hotel Rusesabagina Foundation and PDR Ihumera exerted against the government of Rwanda, and specifically against Paul Kagame. Although I began to withdraw from my volunteer work at the foundation by the summer of 2010, once my student had completed her internship, I did attend one last meeting, as I mentioned earlier, on September 21st, 2010. Paul Rusesabagina was not in attendance at this meeting, but the American leaders were. I took detailed notes during this meeting, which I still have, which centered on the U.S. conflict mineral bill, the Spanish indictments against 40 RPF members, as well as the upcoming United Nations MDG meeting in Spain that was co-chaired by Paul Kagame. During that meeting, American Hotel Rwanda Rusesabagina Foundation leaders described the foundation's efforts to put pressure on the Spanish, I have here Prime Minister, but I think he may be a king, to not meet with President Kagame for the MDG meeting. One of the American leaders stated, quote, our message is, do you really want this guy as the face of the MDGs? They also explained how the foundation helped the quote-unquote Spanish delegation get various meetings with missions to the United Nations, including the Mexico mission to the United Nations, as well as Spain, France, and Turkey. They also explained that the foundation had provided information obtained from PDR Ihumera members which was used in the UN mapping report. They talked about how Rwandan local defense forces had demanded that Hutus dig up their family members' bones for more genocide memorial sites, even if their family members had died years prior to the genocide. And that they did this because they wanted to create more genocide memorials and bones naturally deteriorate. They added that Providence Rubengisa and Pio, who I'll talk about later, had family members die in the genocide, and their bones were on display, and there was nothing that they could do about it. I recalled that during my interviews with Mr. Rubengisa, he stated that he was fortunate that he had no family members die during the genocide. So I knew this was false information. Whether the American leaders of the foundation knew, I wasn't sure. I'm now going to talk about how I began to collect names and details about PDR-EHumera members and why I chose to do this. By late spring of 2010 is when I began collecting names I saw in various newsgroup emails and other emails forwarded to me. As I would come across additional information about an individual through Googling, additional information from the emails, or Facebook if someone had sent me a friend request, I would note that on the document. My motivation for researching the members of this network was rooted in my growing belief that these individuals were actually the former regime, or at least allied with them. In fact, I had recently discovered that a founding member of PDR-EHumera living in the United States and very involved in the foundation was wanted by Interpol for genocide. I was also concerned that this network was purposely misleading the American public and fundraising under false pretenses, including in my own community. I'm now going to shift to another important issue that is related to Providence Rubengisa's email account. As I mentioned earlier in my testimony, Mr. Rubengisa had initially given me the password to his email account for specific purposes. But by early 2010, he authorized me to monitor his email account so I could regularly respond to potential donors, to organize shoe drives, and coordinate other agency activities. This required that I review various emails to ensure I was catching the emails, warranting a response, as well as reviewing older emails for previous donors he'd lost touch with. He had over 10,000 emails in his email account, most of which were in Kinyarwanda, but many others were written in English or had English subject lines or were written partially in English. On a few occasions, relatively early on, I saw things that caused me alarm. For example, I saw a 2009 email from Pio, who was Paul's assistant in PDR-EHumera, to the leaders of PDR-EHumera, informing them of an important upcoming meeting. The email was written entirely in English and stated the following, quote, all, comma, this Sunday, May 24, 2009, a meeting of the Rwanda Legal Assistance Initiative has been scheduled. The conference call meeting will take place at 2 p.m. Eastern Time, USA, or 8 p.m. European Time, and then it provided the number. Reports from diverse media outlets this week indicate that a second military operation is about to be launched against the FDLR by the UN's MONUC, M-O-N-U-C, peacekeeping forces, and the DRC Army. Traditionally, UN peacekeeping forces do not take sides overtly in any conflict, but that's exactly what they are doing in the DRC conflict. We need to find a way to expose the criminal nature of this bias in order to save our FDLR brothers and sisters under threat of extermination. We will also have an update about the ongoing persecution of Leopold Munyakazi. Please notify your friends about this meeting and its critical importance so they can attend in big numbers. Looking forward to meeting you all Sunday. P.O. This and other information I saw led to my decision to start taking screenshots of any emails I happened to come across that I found particularly disturbing. In total, I took approximately 121 screenshots of emails. Some examples include an email dated April 29th, 2010, with the subject line, DC meeting, from P.O. NGILIKILIKESHA to Jerome, NAYIGIZIKI, Dr. Eliel, ELIEL, and TAKIR, UTIMANA, Providence Rubengisa, Paul Rusesabagina, Emmanuel Matata, MATATA, and Emmanuel Haki Zamana, containing several photographs of their meeting and the message, which was, I translated it. These 7 big leaders are part of the brain trust of the next big thing in Rwanda, the PDR-Ihumera revolution. The team I see was in good shape, but it was worth it. Be strong, P.O. Mr. Rubengisa later explained to me that the purpose of the DC meeting was for PDR leaders to discuss their selection and support of Bernard Ntaganda in the August 2010 presidential election, and their plans for Paul Rusesabagina to take over as president in the event that Ntaganda was elected. There were also numerous photos included in that email of themselves. I also took a screenshot of email communication among PDR-Ihumera leaders sharing edits of Paul Rusesabagina's letters to diplomats and politicians critical of the Rwandan government, and specifically of President Paul Kagame, that were later disseminated under Hotel Rwanda Rusesabagina Foundation letterhead, including letters to former President Bill Clinton and Congresswoman Nancy Pelosi. Email communication between PDR-Ihumera leaders editing a press release regarding Paul Rusesabagina's meeting with Representative Nancy Pelosi on May 15, 2007, citing numerous criticisms of the Rwandan government and stating that the only way for the country to move forward was for Kagame to be removed from power. This letter was later emailed to a foundation leader for dissemination on foundation letterhead. 2010 email from PIO to other PDR-EHumera leaders, including Paul Rusesabagina, with an attached lawsuit filed against Paul Kagame during a recent visit to Oklahoma. A May 2010 email of a news group posting with members of a non-political charity in the United States with the initials of OPJDR that I later learned was associated with PDR-EHumera, with edits to Paul Rusesabagina's letter to France's then President Sarkozy, criticizing Paul Kagame, with numerous comments and edits by PDR-EHumera members. A May 2010 email from Emma, M-A-T-H-I-E-W, to PDR-EHumera leaders, including Paul Rusesabagina, Pio, Jerome, someone named Eleazar, L-E-I-E-Z-A-R, Z-I-H-E-R-A-M-B-E-R-E, and Emmanuel Hakis Zimana, who was in Canada, with an attached article written by Calixte, C-A-L-L-I-X-T-E, last name spelled M-B-A-R-U-S-H-I-M-A-N-A, who underneath his name said he was the executive secretary of the FDLR, entitled, quote, FDLR Reactions to Recent Events in Rwanda and to Various Statements Made by Rwandan Officials. An email from Mr. Rubengisa to Paul Rusesabagina with instructions on supporting P.S. Imberakuri. A May 2010 email from PO to PDR leaders, including Paul Rusesabagina, with Paul Rusesabagina's statement and denial in response to Rwanda's accusation that he was supporting the FDLR, which was later disseminated on Foundation letterhead. An email from Providence to someone with the name Gloria regarding his ability to obtain 22-karat gold, cassiterite, and coltan from Africa. Additional emails regarding mineral dealing among Mr. Rubengisa and others in PDR-EHumera, sourced out of the DRC, including lead, ore, O-R-E, I'm assuming that's ore, copper, coal, beryl, and M-A-N-G-A-N-E-S-E. And each of those has O-R-E after it. Once I was relatively confident from what I read and observed that PDR-EHumera members were either the former regime or allied with the former regime, some of whom I believed had been members of Interahamwe, and based on my understanding of genocide research, were engaging in genocide denial and the dissemination of propaganda very similar in nature to the pre-genocide propaganda campaign. I made the difficult decision to copy to PDF any email that I found particularly disturbing. Ultimately, over the course of several months, I copied approximately 747 emails and downloaded approximately 1,076 attachments. The following is a summary of just a few of these emails and attachments that I was able to translate and that I believe are pertinent to this case. I downloaded the PDR-EHumera founding documents that were email attachments sent to PDR-EHumera founders. An email exchange dated June 21st, 2006 that included critical comments about the early formation of PDR-EHumera and the lack of information about the party that was posted on Rwanda Net, which was one of their Yahoo news groups. The email that contained the newsgroup posting was forwarded to PDR leaders with the following comment in response to the criticism, quote, "Since you live in Paris, I inform you that Mr. Paul Rusesabagina, accompanied by some officials in the Party for Democracy in Rwanda, and in parentheses, PDR Ihumera, will be in Paris this Saturday, June 24, 2006, to meet members of the Rwandan community living in France, wishing to be informed about the PDR Ihumera party in general and on the role of Paul Rusesabagina in particular." That comment was written by Pio. He then responded to the PDR leaders included in the email, writing, and this is translated, quote, "Be strong. I think," someone's last name, AYI, is doing a fantastic job. And I believe this was in reference to his response to the criticism. Janvier may have the problem that Muriai seems to be alone in the field. I don't think there should be any concerns, but we will all be very soon on these discussion groups. And it is impossible and even unwise to react to all kinds of concerns on the net. In most cases, especially in politics, it is wise to keep silent and to let people guess. We have to cultivate the mystery from time to time. I am sure that Kigali is already trying to figure out which foot to dance in front of, but that also could have been figure out how to respond to the new organization. That said, these meetings we plan to hold on the weekends are crucial because we need to have something to announce to people at a better time. Also, are there any French and Kinyarwanda versions of the declaration? If so, good. If not, we must create them as soon as possible. Should we also write the speech and perhaps also the text of the press release in these two languages? Here's an idea. Last weekend was a big hit. We need to think about the next move, and the next, and so on. I mean a more or less spectacular event that is somewhat headline-grabbing. It's a great thing that Paris will follow next weekend. But do we already have to think about the weeks and months to come? Pio. The PDR Ihumera leaders included in this email were Clement Gerard, Pio. In that email it was spelled NGILIKILIKESHA, Antoinette, UWIMPUNDU, Emmanuel Hakizimana, Emmanuel Matata, John Calvin, RUTTIMAN, last name NTAKIRUTI, Angelique, UWILIWABO, Michael, SHYIRAHAYO, Etienne, TWAGIRUMUKIZA, Janvier, BUSOGI. He was also the individual who released the FDLR press releases. Celestin Kabanda, 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 and I found out that he was a former member of the MDR party in Rwanda. And Celestin, M-U-H-I-N-D-U-R-A, that I found out later was ex-FAR. Dr. Ilil, N-T-A-K-I-R-U-T-I-M-A-N-A, who I believe was the son of Elizaphan, with that same last name, who was a Seventh-day Adventist pastor, who was convicted by the ICTR in 2004 for crimes of genocide. Anastasi, A-N-A-S-T-A-S-E, R-E-K, last name is R-E-K-E-R-A-H-O, and then Providence Rubengisa and Paul RUSESABAGINA. On October 9, 2007, October 9, 2007, email from Pio with a press release in response to accusations that Paul RUSESABAGINA was a genocide denier and a founding member of PDR Ihumera. And in that press release, he stated, quote, "Finally, we want to make one thing absolutely crystal clear. Humanitarian Paul RUSESABAGINA is not a member of PDR Ihumera." An email from Jerome, who was the PDR secretary, to PDR Ihumera members, including Paul RUSESABAGINA, with a reference to a Jesse Jackson Rainbow Push fundraiser on September 6, 2007, and a PDR meeting that next day, and then a meeting with Jesse Jackson, and a September 9th attendance at a church event. The email begins, quote, "In Chicago, they will be meeting," and then he included the word R in all caps, R-U-K-O-K-O-M-A, and then stated, "I don't want to use this word, but this is the word that we all understand very well." And then there was a document attached to an email to PDR members with an attached list of documents to be reviewed at the big PDR meeting in Brussels, and an email dated 2010, October 10th, 2010, from Celestin, M-U-H-I-N-D-U-R-A, who was a founding member of PDR Ihumera, who at the time lived in Wichita, Kansas, to other PDR Ihumera members, referencing the development of what he called a national council to coordinate all of their efforts toward, quote, liberation. The email had an attachment named CEPR chart, October 10 draft, which was the charter for this proposed national council. The council was described as an umbrella organization for the political efforts of NGOs, including IDD, OPJDR, DIR, FFDR, RAYA, HRRF, and CRD, and the political organizations PDR and RUD, followed by an ellipses indicating that the list was incomplete. The document also included track changes by Celestin, who was not only a founding member of PDR Ihumera, but was also the founder of IDD, one of the NGOs listed. An August 12, 2010, email exchange between Clement Gerard, Providence Rubengisa, Augustin, NDA, HAYO, and PS Mburakuri, referencing their commitment to financially support PS Mburakuri through donations received by IDD. PSM Burakuri referenced needing financial support for more militants. Providence Rubengisa referenced the UK decision to stop aid to Rwanda until the government released all political prisoners. Clement responded to the request for financial support with, quote, "We consulted with Celestin and he agreed to donate as much as we could through IDD. So now I am going to ask how much is available. I gave my 100, close quote. Numerous emails and attachments about Rwanda briefing, inter-Rwandan dialogue, and the Spanish indictments. A September 2010 email from Octave MUGABOWINEZA to PDR eHumera leaders in reference to Paul Rusesabagina's project to push the ICTR to prosecute Paul Kagame and RPF members. And there was an attachment entitled Task 1.doc, and the email included instructions on collecting testimonies on RPF crimes that were to be provided to the United Nations, with the hope of adding the testimonies to the mapping report and also to be shared with U.S. legislators for lobbying purposes. Emails regarding PDR eHumera's coordination and support of PSM Burakuri, including what appeared to be reports to PDR members and Paul Rusesabagina on prison visits. And then emails written by Mr. Rubengisa's American partner and his host family in GFR to a group of evangelical Christians in support of Mr. Rubengisa's political asylum application, which was apparently held up due to an accusation of genocide. And an email by the same American to James D. Kay with the U.S. State Department, vouching for Mr. Rubengisa, stating that in his heart, he did not believe Mr. Rubengisa committed genocide. I believe the State Department employee was targeted by Mr. Rubengisa, who had met his daughter through the same refugee resettlement agency I referenced in the beginning of my testimony, who then referred him. And I later learned that Mr. Rubengisa was granted political asylum in the United States shortly thereafter. When I evaluated the emails collectively, which took me a very long time, what I was able to glean from them, combined with my other sources of information, was that Mr. Rubengisa and Paul Rusesabagina appeared to intentionally target Americans with political connections and other talents, such as writing. One reason why I believe this is because whenever Mr. Rubengisa would make a new connection with an American, including myself, or achieved a specific goal, such as fundraising or facilitating a big shoe drive, he would often forward the relevant emails or media articles to PDR eHumera leaders and his family members in Belgium and Rwanda, reporting on his progress. It also appeared as though most of the political opposition groups worked in very close coordination, and org charts that were included as email attachments appeared to indicate that they were all related. Something I found particularly disturbing was that many of the PDR eHumera members, who I had been able to trace as having been members of the former regime, ex-FAR, were not only self-identifying, as I mentioned before, as genocide survivors, but had been able to obtain positions as African scholars at universities and at genocide research centers, such as the Strassler Center for Holocaust and Genocide Studies. And some had even received scholarships reserved for scholars working to prevent genocide. Others were in policy positions in the United States and Canada, and some even held UN positions. It was very clear in their internal discussions that they used these positions to disseminate propaganda, narratives of the genocide that were not supported by experts and scholarship, but were consistent with the pre-genocide propaganda campaign, a double genocide theory, or a Tutsi genocide against the Hutu. There were also emails and attachments about the Veritas Rwanda Forum and the Intro-Rwandan Dialogue that appeared connected to the Spanish indictments of 40 RPF members. Emails regarding 2 meetings for the Intro-Rwandan Dialogue included names of those who attended, and I noted that most of the attendees were members of PDR-Ihumera, including Paul RUSESABAGINA and Providence Rubengisa. I now want to talk about another grouping of emails I obtained that contained information highly relevant to this case. At some point in approximately 2009 to early 2010, before I had become suspicious, I agreed to allow Mr. Rubengisa to use one of my laptops. When I got the laptop back later, I noticed approximately 80 emails in .eml format, which is Microsoft Outlook. They were contained in a temporary file. I ultimately moved them to a permanent folder. I saved them in PDF format. I also made sure to save them in their original format. Some of the emails I took screenshots of as well, and you could see at the top of the photo a reference to the temporary file. Among these emails were the following. Emails from 2007 describing a Hotel Rwanda Rusesabagina Foundation Rainbow Push fundraising event, including emails sent by American Foundation leaders to PDR-Ihumera members, coordinating planning, an email from Jerome, Naygiziki, to 51 what appeared to be PDR-Ihumera members, but this one did not have any American Foundation leaders included, with an itinerary for the event, including the Rainbow Push fundraising event on September 6th, a major PDR-Ihumera meeting the evening of September 7th, and another event on September 8th, and emails describing the Foundation's planning for a Truth and Reconciliation Commission. An email dated January 23rd, 2007 from John Calvin, NTAKIR, Elizafan of the same last name, notifying 25 PDR-Ihumera leaders, including Paul Rusesabagina and Mr. Rubengisa, of his father's death. The email characterized his father in very positive terms, including stating that he, quote, lived a life of service to the Lord. John Calvin also thanked the email recipients for their support and prayers. Emails from and to Mr. Rubengisa that indicated his for-profit shipping company was conflated with his not-for-profit organization, Stuff for the Poor, with regard to shipping containers of used items to Rwanda and Tanzania to be sold. More emails from and to Mr. Rubengisa about mineral dealings in the Congo. A June 18th, 2000 email from an American leader of Hotel Rwanda Rusesabagina Foundation to Jean-Pierre Busogi and Mr. Rubengisa approving of their draft and a letter to President Bush from Paul Rusesabagina with suggested edits. A May 14, 2007 email from PO to PDR and Foundation leaders, including Paul Rusesabagina, with a draft attachment with PO's edits for a Foundation press release announcing Paul Rusesabagina's meeting with Nancy Pelosi on May 15, 2007. A September 20th, 2006 news group posting containing the text of Paul Rusesabagina's September 20, 2006 letter to President Bill Clinton, posted by a PDR Ihumera member asking for edits. Also, Providence Rubengisa's Skype was still, and I could see the screen from his last conference call and all of the attendees' mobile numbers. I still have the text where I told him that he left his Skype logged in, and that I was alerted to this because he'd gotten a call. And I took a screenshot of the screen and still have that in my possession. I mentioned before that my realizations evolved slowly and simultaneous to other experiences. I did not read and understand the emails immediately. Rather, it took me time to go through them and make sense of what I was reading, including piecing together what I could translate. I am now going to talk about a collection of emails that I believe is the most relevant to this case. Around the summer of 2011, as I was reviewing all of the emails, the screenshots I took, the emails I copied to PDF, the emails left on my laptop, I noted a collection of email exchanges I found very worrisome. Despite not being able to read them, I noted references to money, Western Union, and some names of people that I knew were affiliated with the FDLR. I eventually had some of them translated. In total, I have in my possession 33 email exchanges between Mr. Rubengisa and someone by the name of Fernando, last name Ngamiji, which I have reason to believe was probably a pseudonym, who was a self-identified fighter with the FDLR in the DRC. Some of the emails CC'd Paul Rusesabagina, Jerome, Naygiziki, and Dr. Eliel, who also went by Dr. Nataki. At least 2 of these emails were sent directly to Paul Rusesabagina with a forwarded email of Fernando's email attached. Once I was able to read some of the emails, I immediately recognized that they were not propaganda like so many other emails, but rather they represented concrete attempts of PDR Ihumera, including Paul Rusesabagina as the party's leader, to provide financial support to the FDLR for the purposes of, according to the emails, violently overthrowing the Rwandan government. The emails discuss amounts of support, how money would be transferred to the FDLR, Western Union information, Paul Rusesabagina's trip to South Africa to meet with first name IGNACE, last name MUNYESHYAKA, who was an FDLR leader, for the purposes of buying weapons, and also included detailed information on the weapons requested by the FDLR soldier and a discussion of how and where the weapons would be purchased. In one email, Mr. Rubengisa refers to sending him a container that Fernando could sell, which I believe was a reference to the containers Mr. Rubengisa used to ship used shoes to Central Africa through his for-profit company and not-for-profit charity Stuff for the Poor. PDR eHumera budget information was also discussed in an email from Mr. Rubengisa to Paul Rusesabagina. The FDLR commander seemed to regularly report on the events in the battlefield, and Mr. Rubengisa consistently assured him of Paul Rusesabagina's and PDR eHumera's support, stating in one email, quote, "We will never fail you." Mr. Rubengisa referenced the Hotel Rwanda Rusesabagina Foundation fundraiser with Jesse Jackson's Rainbow Push organization in Chicago on September 6, 2007, and stated that one of the agenda items for PDR eHumera's meeting on September 7, 2007, was the issue of providing financial support to the FDLR. Other emails had a subject line and discussion referencing Ambassador James Kimonyo accusing Paul Rusesabagina of traveling to South Africa to meet with the FDLR in relation to buying weapons. I have turned over this set to the Prosecutor General, along with the other relevant emails and documents, but I would like to read a few of them. A few of the more pertinent emails as a part of my testimony. On March 22nd, 2007, Fernando wrote, "I received your message. We've already prepared the financial needs. I have already found a priest who will be helping us so that the money can more easily reach us. He will be working with another guy in Kampala who will also be facilitating money transfers to us. I've already selected people who will be working on that, but I'm still waiting for you guys to send the means. But it should be a secret between you, because this thing needs sacrifice, because we are in the middle of the enemy. So please try to do something, despite the fact that conservatives are here, so that we can work with the courageous ones. I am waiting for a reaction with the determination to win." At 10:07 a.m., Mr. Rubengisa responded, "Hi, I will speak to Jerome and Paul and Doctor so that I can give you a response, but please know that it is positive. Are you still in communication with the guy in South Africa who you told me met with Paul? Otherwise, we shall put you in contact with him. We've chosen a person who will be your contact that you will be speaking to, particularly on your needs and steps. He is in the U.S. military, but he is a Rwandese, and we agreed that we are going to put him in contact with a guy in South Africa, and then the guy in South Africa will give him your contact information. Otherwise, those kinds of people are everywhere. Even in our case here, people don't have the same logic. So is it okay? Should I be able to send you the news? Are you able to read? Thanks." On April 13th, 2007, Mr. Rubengisa sent an email to Paul Rusesabagina, forwarding an email from Fernando stating, "Paul, Fernando is serious. I think we should talk very seriously. I will call you to talk about GFR because they have already asked you to give up that grant you have given them, and you will need to accept that they will use it in another country. They already put on the internet that GFR will move to Uganda. Be strong. Read that Fernando message below. Fernando's message reads, "Good morning. I have received all of your messages. Now I think that the person you used to ask me about has already talked to Malumba, and he has also sent me the news he shared with him, which should concern us as the people challenging Paul R. ideology should not be an issue. You should start working on that, but know that the start cost is a lot of money because of the work that it requires. We need at least $500,000 for the first 5 months. And Paul R. should plan that most people will show up because of the propaganda of his politics in the youth, as we do not want to stay in the jungle without any progress. My regards." On July 9th, 2007, Providence forwarded this email to Paul RUSESABAGINA and Dr. Elil, stating, "The people I spoke to told me they have asked for a budget of $500,000/5 months to support their work. But I asked him to work on a small budget and look at how we can support them. Be strong." On August 9th, 2007, Mr. Rubengisa wrote to Fernando, "I just wanted to know if he could be your liaison in South Africa. There are other small issues that you should also start looking into. For instance, to send you money if the Western Union method is not working, if Kagame closes the other area. What would be Plan B? I have another question for you that I think I'll be asked by my colleagues here. Now that we've started working together, what about those people that you've been working with? Now that we're going to be supporting you financially, if things go well, is this going to create any problems between you guys? In fact, you should talk and let us know about your position. Can you guys find the landmines there if we give you money? What about those that can bring down the birds? Can they be available from there? If you think you have those that can bring down the birds, military tanks, and the landmines, do you think that will be enough for you to carry out the operations? In short, you let us know what you need and what you have there, then we can also start beginning to look around." Fernando responded, "How are you? I got your message. It was very long and clear. As for the equipment, you should try to find them there. Those that are available locally, I didn't put them on the list. But what I can say, there are different kinds of equipment that will enable us to counter the force, because those birds and those equipment that move on the chain makes him so proud. But Plan B is still there, and there could be another plan. Okay, talk to you later." On August 22nd, 2007, Mr. Rubengisa forwarded the August 9th email to Dr. Elil, Paul RUSESABAGINA, and Jerome, stating, quote, "Please read this attached message. The rest we shall discuss when we are in Chicago." On August 27th, 2007, Mr. Rubengisa emailed Fernando with the subject line, quote, "6th event," which was the date of the Jesse Jackson fundraiser, stating, "I received your response And I think this will go through because a lot of people are negotiating with us so that we can work together. We are also still thinking about it and seeing if we can do it. The problem here, are you guys working with them? What about their saying about people who are on this side or that side? What is all that about? Please respond, because we have a very big meeting in Chicago. That's where we shall discuss your problem in detail, because there are things we don't want to discuss on the phone. It will be better for you to be together and avoid divisions. And by the way, what is your position? If you have any more information that you want to send to the members of our party, you can let me know. But it would be better if you wrote a message so that I can read it in the meeting. It would be interesting for the people in the meeting to hear that I am reading your message. Be strong, be vigilant. We are doing the same, and we shall never abandon you. Providence. On September 17, 2007, Fernando wrote an email with the subject line, Paul R. versus Camonio, and in parentheses, USA, stating, "Hi, I received your information. I heard on Voice of America Kinyarwanda program, Paul Russes and Camonio and others. Even though Kagame doesn't accept the opposition from our side, I believe he will one day bow down. It's just a matter of time." Mr. Rubengisa responded, "How are you? Has the fighting stopped? There is a time you told me these people who are helping you politically, but you didn't tell me who they are, because for us, in PDR, people are confused. Those divisions that we are hearing about between you, are they for real? We are hearing that Munyeshayaka is on the other side. What is that? What we really want is to know where we stand exactly, because we want everyone to be on the same side so that we can fight Kagame, because he is our problem. Those divisions serve nothing other than making him stronger. People are absolutely ready to contribute money every month, but we want to do it in a manner that shall not make us go backward or fail, but to be able to sustain and never quit. So please help us and look at those small issues and address them. Talk to your guys, and I'll talk to my guys, and we'll find a solution. Thanks. On October 11th, 2007, subject line, Ray, forward, U.S. ambassadors accused of arms dealing. Fernando wrote, "How are you? On this side, we are okay, and the fight against Nakunda is going well. We are very optimistic because he has already lost a lot of his positions. He is now in the mountains, close to the bamboo forest. Please send me again your message because it didn't come, except the subject, because I am waiting. Who knows what happened to that message? Stay well." At 4:20 p.m., Mr. Rubengisa responded, "Hello, we are okay and we are very happy because of how you are hitting Kagame, since there is no difference between Nakunda and Kagame. I met Paul face to face on the other issue of supporting you, and he accepted your proposal, and we agree that we are going to do mobilization so that we can start sending you the support at the end of December. I also told him about the other equipment that you've been asking for, and asked him to speak to our businessmen in Europe. and see how we can find those in Asia. He told me that he is in contact with MURWANASHAYAKA. Oh, yeah, okay.
Niki.
Okay.
Niki.
She asked me if I needed a break.
Urukiko nabwo rurabibona ntabwo ari inshingano zawe ngira ngo tubibona turaza kubimubaza. Hari ako ukeneye? Hari akaruhuko ukeneye umutangabuhamya?
In a few minutes would be good. Just in a few minutes. If I could get through these, then I'd like to take just a quick break.
Usigaje bingana iki? Ibisigaye.
I just have a few more.
Okay.
Okay.
Ubwo wakomeza niba wumva ukeneye akaruhuko tubwire tukaguha.
Okay. I will. Thank you. I'm just trying to find my place. Hold on one second. Okay. I'll reread this. At 4:20 p.m., Mr. Ruben Gisa responded, "Hello, we are okay and we are very happy because of how you are hitting Kagame. Since there is no difference between Nkunda and Kagame, I met Paul face-to-face on the other issue of supporting you, and he accepted your proposal, and we agree that we are going to do the mobilization so that we can start sending you the support at the end of December." I already read this part about Asia. Even though other people have limited capabilities, we have our Paul, who was given to us by God because he can reach anywhere. But the good thing with him is that he wants us to be united because divisions will not help us except giving our enemy a new momentum. So you guys should start organizing people who will be receiving the money, and you should take a strategy of changing these people periodically, because even on our side, we're going to be changing people who will be sending the money, but not more than 15 of them. Do you think after you finish Nkunda, that gentleman there will help you cross back? NB : I forgot to tell you that Paul told me to ask you if changing your name and dividing yourself into two groups just for political reasons, if that would be helpful to avoid the fact that we are on the list. Second, do you think that if we were to seek the support from Tanzania to allow our people to pass their way for training, do you think that will be better? So you let me know. Please continue to update me on the news of the battlefield. On October 28, 2007, with the subject line, U.S. ambassadors accused of arms dealing, Fernando wrote, "Hi, I understand those contacts that MURWANASHYAKA and the other guy have, but I know our organizations from its roots, and that is possible. But there are a lot of conservatives in different decision-making positions who don't want change, but we, the youth, we want to move forward, but for them, no, they don't want to. I think for me, the guy you spoke to should be the guy who should be given the position of president. The rest should be his assistants. And I think that's the reason why, because of their selfishness, they don't want to change the name, even they know the list exists. So the second proposal of having two organizations is what we have chosen. So those who do not agree with us, once they are weakened, they will come by themselves, because we have to be prepared to execute our plan in advance so that Kabila cannot maintain his power, hold on to power by sacrificing us for the sake of diplomacy. Otherwise, somehow we are currently working with people here about our infiltration into Goma, Butembo, Rwanda, and Kampala. He will never tell where we get our means. Whatever bad things he wants to do to us, he cannot succeed. And about the possibility of helping us to cross back, I don't think he has the heart, because I know for sure he is afraid of Kagame. His army is weak, and Kagame's infiltrators, especially those generals who served in RCD, they still work for him to the extent that they can even spoil what we are doing. Another point is that if we create a second organization, Kagame will not be able to say that it is the FDLR that changed its name, because by the time he will be saying that, what is important is to capture Rwanda, and then everyone will get their share. Second, to get the green light from Tanzania is very important, especially because if they agree, Kagame will be finished, and that will help Kabila be courageous. And Tanzania is more influential than any other country in the Great Lakes, particularly on political, military matters. That means victory shall have come, and the enemy will be obliged to defend himself on many different fronts, and he is going to be weakened from all over. In fact, tell him to move faster, because Tanzania has a successful history of helping people get into power. They are unstoppable. It's a known fact in the region. 3, briefly, the president of the outside opposition, who is credible, should be the guy that we speak to, so that CI and USA should bring us together, coordinate us, because we are the majority. Speak to you soon. Mr. Rubengisa responded, are you okay if I take a really short break right now? I have just a couple more emails, but they're a little long.
ntacyo bitwaye.
Okay.
Katube tugoye akaruhuko
Thank you.
wabuze cyane.
Thank you.
Fate nk'iminota 10 turebe ko umutangabuhamya yaruhuka. Iburanisha ribaye risubizwe. Waba wisubiriye mu mwanya ukaba wicaye. Bamufashe.
Thank you.
twasubitse mu minota 10 ntacyo turi gukora ukeneye gukora iyo gahunda ntabwo turi kuburanisha ufitiye kugera hanze yahagera mu minota 10 kugira ngo mutangabuhamya ze kugaruka tuze kumvikana icyo turi gukora.
urukiko rurinjiye.
Nimwicare. Sinzi abari ku buhanga bw'ibyuma byakunze. Okay, mbere yuko umutangabuhamya turasubuka iburanisha twari twasubitse. Birakunda. Mwihangane gato ntibirakunda. Mbere yuko umutangabuhamya agira icyo atangira kuvuga, abandi byakunze ngira ngo noneho byakunze. Okay, amasaha aragiye, turagira ngo mbere yuko umutangabuhamya ko twemeza ko akomeza tuvugane. Urabona uko tureba, turabona hari ibintu byinshi agifite byo kuvuga. Kandi urukiko rushobora kugira ibibazo narwo rubaza n'abandi baburanyi. Sinzi gahunda y'umutangabuhamya imeze ite. Ku buryo ejo mu gitondo kubera ko dufite iburanisha twamuheraho nka saa tatu n'igice akaba arangije. Hari icyo ubushinjacyaha mushaka bivugaho? Reka rimwe tubaza noneho nawaze ko
Nyakubahwa Perezida, twari twabonye ko afite ikibazo, ntabwo byari byatangiye gukora, icyo twariho tureba ariko byakunze noneho arumva. Merci.
ngira ngo noneho bisa naho byakemutse. Umutangabuhamya uratwumva neza? Urukiko rwavugaga ko amasaha asa n'agiye, tugeze hafi saa 11, kugira ngo tubaze gahunda ufite. Ejo dukomeje ugakomeza nka saa 3 n'igice ukaba ushoje, kubera ko tubona ugifite ibintu byinshi kandi hari abantu benshi hano bigaragara ko barambiwe.
I just have a few more pages.
Ku buryo urumva byafata nk'igihe kingana iki?
Maybe 10 minutes.
ngira ngo abandi mwakwihangana iminota 10 ntabwo ikiri myinshi tugasoza no mutangabuhamya mwihangane nta minota 10 ntabwo ikiri myinshi kugira ngo ejo tuzatangirane n'undi. Okay, noneho wakomeza.
Okay. Providence responded, "Hi, there's a lot happening in a very quick way, to the extent that there are things that we have to do quickly so that we don't lose the opportunity or even find out if these people have adopted or taken another solution, especially in this area where we Hutus are. So people have adopted or taken another solution, especially in the area." I'm sorry, I just repeated that. So the information we have is that Americans are tired of Kagame, but they are saying that because the information we have is that but they are saying that because Rwanda is peaceful, we have to leave it the way it is. So we have to do everything possible so that something happens as soon as possible. And that thing about the name is very urgent, but I will let the other man know that you are in agreement, then we shall discuss about the name. Murwanashyak. These people here, they don't even want to hear his name. They say he is a negative force. This was said last week. So tell people, your people, that we actually know he is innocent, like many others, but we have to be very intelligent in how we make our decisions without just pleasing ourselves, but finding a way of making the Westerners happy. And then after those who are innocent will be cleared. But if we don't play it well and have a very good strategy, we shall lose. And yet things are moving very well in our favor. We met with the Congolese, those who came with Kabila, one of our guys, and their Minister of Defense. We wanted to see if we could negotiate a fighting base. What we got from that meeting is that Congolese are tired of Rwandese, whether it be Hutu or Tutsi. What they want is that those tensions between Hutus and Tutsis, we should take them back to our country. We didn't reach any agreement because that man, it is said that he is not on good terms with Kabila, so he's not powerful. So we are pushing to see if we can see the big boss. Please try as much as possible to convince those people, the Congolese, to make them understand that we need everyone's support, and that if they see anybody whose motives are to be in a power struggle, they should avoid that person. Here in America, we are fighting for the ordinary people, because I don't think even when we capture power, we will leave our jobs and go back. Question: if you get the financial support of 50,000 USD per month, can you do something, even without a base? Please try to think quickly, because things are moving faster in the region, and we have to move just as quickly. Stay well. On November 17th, 2007, Mr. Rubengisa wrote, "We're going to start on the 5th of December 2007. Paul told me that Murwanashyak seems to be dragging his feet and that he was not able to see him. He called him and asked him to come to meet him, and he told Paul to instead come to his house. But instead, Paul gave him Jerome's contact so that they could meet in Brussels in 2 weeks. So please send me the names of the people we will send the money to. Please know that the amounts will be increasing every month because we agreed to start with a few people, and then we shall increase the amount every month. Stay well. NB : this time you'll get the money from Goma, but give us different people's names. Fernando: hi, here are the names of the people who will cash the money from Goma. As you had asked me, they are, and then there's 3 names. and then North Kivu, Goma, DRC. But when you are done with transferring the money, those through Western Union, please send me on each case the name, last name, first name, address, telephone, amount expected, town and country of origin, money transfer code numbers, question and response. That will ease the operation. God bless you. On November 18, 2007, Providence forwarded the November 17th email to Jerome and wrote, Jerome, send this email to Antoinette. Next month, those are the people we are going to send the money to. Thank you. The last email was sent by Fernando to Mr. Rubengisa on December 11th, 2007, stating, hi, it's Fernando greeting you, and I want to inform you that I changed my email address because my old identity is known by many people, and I get a lot of messages in my box that are mixed, so I will close it in 1 week. So correspondence shall be sent to this email. What about the other program where Jerome was going, Mirashwanyaka in Brussels? Did that happen or not? When is RUSESABAGINA expected to arrive in Lusaka, Zambia? Because there are people who went there to steal his assets. I'm following minute by minute, but accept that their ideology is short-sighted because they will not succeed. That is what I am getting from people who called me on the phone. That is it for today. Once I discovered that Paul RUSESABAGINA, Mr. Rubengisa, and their associates with PDR Ihumera were engaging in these activities that seemed likely to be illegal, I turned everything over to U.S. law enforcement and cooperated with an investigation from approximately February of 2012 through early September 2012, serving as both an advisor and as an informant. During several of the meetings I had with Providence Rubengisa, they were also monitored by U.S. law enforcement. I want to mention something right now about that I think will impact potentially my credibility, and I want to be very transparent. I mentioned earlier that I came to Rwanda. I came to Rwanda in December of 2011 with another American scholar, academic, to attend a conference. It was my desire at that point, once I handed everything over to law enforcement, to transition to an academic role in support of Rwanda. So I had the hope at that time with the other academic that we were going to sign a contract with Rwanda to help in a more academic way understand the nature of the diaspora relations in a positive way. When I met with U.S. law enforcement, they asked me to postpone that, and I agreed to do that. After I was done working with law enforcement, I then signed a contract with the Rwandan government to provide academic support. Because of the nature of the work I had done with U.S. law enforcement, it was advised to me that I should register for the Foreign Agent Registration Act. I did not have any intention, and nor have I ever lobbied the U.S. government on behalf of the Rwandan government. Everything I did of my own accord. But because I had worked with the U.S. law enforcement, I wanted to be very transparent because the contract involved paying me for my scholarly work. The FARA application is public record. I will talk in just a few minutes about how that has been used against me and my credibility. Very quickly, I just want to say, and I only have 2 pages left. When I met with Mr. Rubengisa, when I was working with U.S. law enforcement, he ultimately disclosed much of what he was included in the emails, including his contact with the FDLR fighter and Paul RUSESABAGINA traveling to South Africa to meet with Mirwanashayaka. I met with him on June 4th, 2012, at a restaurant in the Chicago metropolitan area. I took very detailed notes, and U.S. law enforcement was monitoring this meeting. During a discussion about the FDLR conflict in the region, Mr. Rubengisa stated to me, "You know, I was in touch with them for 3 years ago. I was communicating with them." I said, "Who?" And he said, "A guy from the FDLR." I said, "How do you know he was really the FDLR?" And he said, "I know it was, but then Paul, he messed it up. We were supporting and things like that, and I set the whole thing up. We always did that, made Paul look good. And then Paul went to meet with them in South Africa, and he made so many mistakes. And we think maybe Kagame people got involved. There are people in prison right now because Paul messed things up, so they stopped communicating. They tried to reach out to me again recently because I wasn't sure who it was, because Kagame people always trying to trick us, so I didn't respond. Plus, I don't have to do that now because we can just go through people we know and have them reach their family members. Like me, I have a guy I know who I'm in touch with who was very high up in Interahamwe, who was still in the jungle. He grew up in my dad's village. I can talk to him. So talking to the FDLR people is not hard. So that way, when it comes time to fight, they will be there with us. I said, so Paul wiring the money was true. And I asked, why did he do that in his own name? And Providence responded that Paul would always have other people do it, like him or Pio, but this time he decided to send it himself. Quote, because he is lazy, and thank God he is cheap because he sent so little. The most was 800. Thank God he is cheap. Close quote. During the same meeting, he also told me that he was the one who decided to merge PDR Ihumera to start the Rwanda National Congress, the RNC, because he believed PDR Ihumera would never be successful since they only had Hutu members. He shared that although they weren't initially going to have Paul Rusesabagina join them as a founding member, they did ultimately decide to have him be a founding member in 2011 because so many Hutus followed him and thought he was a hero. They later learned that Paul was working behind their backs to keep PDR Ihumera going and was talking to the editor of an extremist Hutu newspaper run by a Hutu Catholic priest in an attempt to undermine the RNC leaders. So at an RNC meeting in Brussels a few months earlier to my meeting with him, they forced his resignation. One thing I want to talk about briefly was a text message exchange, which I still have. On September 8th, 2012, Mr. Rubengisa and I exchanged texts about their attempts to recruit rebels from Rwandan universities to help start social movements in Rwanda by building cells inside the country. But they were concerned because of the many spies at the university. Providence wrote about a friend of his named Jamaica who was recruiting youth from a refugee camp in Uganda to enter Rwanda and create internal conflict. On September 18th, 2012, we had another text exchange, and he told me that Jamaica and Alexis, B-A-K-U-N-Z-I-B-A-K-E, of PS in Burakuri, were recruiting youth from the Nakivale refugee camp, which was further north from the Rwandan border because it was, quote, more safe. I still have this text message on my phone, and I also have it printed out and saved as a PDF file. One more thing I would like to talk about, I'm almost at the conclusion. It's one of the things I noticed throughout the emails was what I perceived as bullying by PDR Ihumera members and many of their associates and allies of anyone who challenged their ideology or any institution that worked with President Kagame. These aggressive tactics involve subjecting targets to online attacks, and in some instances involve the filing of civil lawsuits against them. Examples include PDR Ihumera members posting messages about books or articles in the Yahoo news groups that they perceived were critical of their activities or perceived as being supportive of the Rwandan government, and then asking members to respond in a coordinated manner. These were not posts debating the merits of the books, articles, or activities, though. Rather, in most instances, they involved online attacks that were often very personal, with many including the individual's employers or publishers in the post. My impression of these attacks was that they seemed designed to intimidate scholars, journalists, church leaders, etc. And from what I could tell, they were very well coordinated and they were highly successful. An example of institutional bullying was the filing of lawsuits against universities that invited President Kagame to speak, and including university administrators in the lawsuit. While these actions may not have been illegal, they did remind me of research on what's called swarming, which is defined as a form of negative online advocacy designed to intimidate and cause harm to individuals and institutions in an attempt to compel an outcome, which in this case was silencing critics and isolating the Rwandan government. One example of institutional bullying is a lawsuit filed against William Penn University in 2012 after the university announced that President Kagame would be a keynote speaker at the May 2012 commencement. The PDR network, which at that point had merged with RNC, barraged the university with letters and a range of threats, mobilizing support through Facebook and various posts from blogs by organizations that frequently coordinated with PDR Ihumera network, such as Friends of the Congo. The university did not withdraw the invitation for President Kagame to speak because they had 4 president scholars, students from Rwanda who were graduating. Mr. Rubengisa and Paul RUSESABAGINA organized a demonstration against the university and filed a lawsuit on May 11, 2012. And according to one of the emails, had President Kagame served during the commencement via his security detail. The lawsuit named co-defendants, the president of the university, Ann Field, the vice president of student advancement, Steve Noah, who had developed the Rwandan Scholar Program, an American attorney who often represented the Rwandan government in the United States, and Stephen Rapp, then Assistant Secretary of State. While I support any individual's right to express themselves through protest and other democratic means, what this network was doing was swarming targets, which again involves the virtual organizing of multiple groups to achieve a particular outcome. When swarming is facilitated by what's called smart mobs, a large networked group of people, it is often considered undemocratic because the goal is to intimidate people and organizations with threats such as what is called nonsense lawsuits. I was so disturbed by these well-coordinated aggressive tactics that I did some research, some online research, and found various empirical studies about swarming and smart mobs. And I also found a publication by the RAND Corporation, a well-respected political think tank, referring to these types of tactics as a form of modern-day warfare. I mentioned before that it was my goal to work with Rwanda in a productive manner within my area of expertise. And I mentioned that I was asked by U.S. law enforcement to wait to sign a contract until the investigation was over, and I agreed to do that. And I signed a contract. I believe it was in October, 2012. I would have to look to confirm that. And I registered with FARA, again, a public document out of an abundance of caution, even though legally I was not required to do so because I was not advocating on behalf of Rwanda. with U.S. legislators. These tactics were used on me because at some point, PDR y Humera found out that I was no longer on their side. And in the summer of 2014, which is when I registered in June of 2014. I may have my years wrong, but I know I registered. In the summer of 2014, when PDR y Humera members and their American allies learned that I was no longer on their side, I was subjected to over 15,000 tweets calling me a Kagame agent and a paid Kagame spy. Most of the tweets included my home address. Some of them included death threats, and all of them tagged my then employer in what I presumed were attempts to cause me to lose my job. I want to conclude my testimony by discussing my motivations for being here today. Walking away, the moment I suspected I was in the midst of a network of genociders, genocide sympathizers, and apologists, would have been so much easier and would have allowed me to protect my career and my private life. As I prepared this testimony, I spent a considerable amount of time reflecting on my original motives, including reflecting on what prompted me to do what I did and to keep going when at times I felt like I was completely in over my head. I felt like I'd stepped into a minefield and I wasn't always sure what to do or how to handle the information I found. I am not a politician, nor do I have the mindset of a politician. And my choices may not make sense to some people involved in the geopolitics of this region. In all honesty, I believe that what motivated me to follow my instincts and take the risks I did relates to my gender. I am a woman and I am a mother. And while most combatants in protracted civil conflict are men, women and children by far bear the brunt of the long-term burden and consequences of violence in this world. And the impact of violence on women and children was and is very personal to me. As a woman and a mother, I feel a connection to women everywhere, including women in Rwanda. I hope this is obvious, but I want to say this very clearly. The Rwandan government never directed what I did. They never did. I did this on my own. They did not influence my testimony. These are my words. And as I mentioned before, I have all the emails and documentation to back it up. It's very hard for me to come here today, but I believed it's my duty as a woman and as a mother to speak the truth about what I know and to find the courage to do something about it, including coming here today and testifying before this court. And that's all I have. Yes.
Wakoze cyane. Reka hari utubazo tubiri dutatu gutya turukiko kugira ngo utange amakuru arushijeho gusobanurira urukiko.
watubwiye yuko hari inyandiko nyinshi wagiye ubika zirimo za email izo wavanaga kuri Facebook mu binyamakuru. Watubwiye ko watangiye kubikora mu 2009 niko bimeze?
I had emails forwarded to me in 2009, but I did not start collecting emails. I have it in my testimony. I think it was approximately May of 2010. I think it was around the middle of 2010. Because I remember that it was after the American attorney came here and got arrested. It was after that point that I was certain that I wasn't dealing with genocide survivors. I believe it was after that point that I started taking screenshots and then I started copying the emails.
Ibyo byose ubyegeranya washakaga kugera kuki? Nihe mpamvu yatumye ugira ubwo butwari bwo kwinjira muri email ya Rubingisa ugakusanya ibyo bintu byose?
First, I'm just a naturally curious person. Second, when I started putting the pieces together and figuring out who they were, quite honestly, I was outraged. I've felt a passion for Rwanda for a very long time, and it was one of my dreams to be able to work and support this country in one way or another. Quite honestly, even back in high school, I had a passion for animals in Rwanda. That's kind of what started it for me. And when I found out that it was actually members of the former regime and genociders and genocide sympathizers, I was outraged. I was outraged by what they were doing. I was outraged that they were taking advantage of Americans. And because of what I do for a profession, I know very well the impact of conflict. And as a mother, I just didn't feel like I could walk away. I just didn't feel like I could have this information. And I asked myself, well, I was teaching an ethics class, and one of the questions was, what would you do if you found out something along the lines of during Nazi Germany? And everyone always answers, I would do anything I could to help people. But that's not what the research shows. Most people don't. They're bystanders. And when I found myself with this access and this information, I asked myself, what are you going to do? And I remember agonizing over it. I was also working with different aspects of Rwanda. I was coordinating with an agency in Chicago that was doing work here. I developed an internship site with CNLG, with my university. So I had I knew survivors in my community, very close to several young survivors, girls, that I actually thought of as my daughters in many respects. And I just didn't want to be the type of person that was a bystander. And that's the best way that I could explain it. I had this access, and I decided to do something about it.
Ayo makuru uratubwira ngo wayagejeje ku nzego z'umutekano za Amerika. Abagusubije iki?
I can't really talk about the U.S. law enforcement case. I've been asked not to, not by anybody here, but in the United States. But all I can tell you is that I participated in an investigation from approximately February of 2012 to early September 2012. And I was not privy to what happened to the investigation after they told me that I was no longer needed in the investigation.
Murakoze. Tugarutse ku nyandiko zivuzwe haruguru wagiye umenya zinyuranye muri screenshot yawe, hari ahantu wavuze yuko watangiye kugira impungenge umaze kubona ko hari ibiganiro bitangiye kuza bivuga ku bijyanye n'ingengabitekerezo ya Hutu Power, noneho no kubyavuga kuri FDLR. Tugarutse ahangaha kuri FDLR by'umwihariko, ese waba wibuka nk'amagambo yaba mu nyandiko cyangwa mu magambo Rusesabagina baravuze ubwe uyibuka wayavuga?
So most of the emails were like a group of emails with numerous email addresses, and his email address was always included. In fact, 2 email addresses for him, one for the United States and one for France. The most in terms of his own engagement with those emails, other than being a recipient, is every once in a while he would post something and say, "For your information," typically in French. And then it would be that, a lot of the members of PDRE Humera and other email addresses as well.
Urakoze. Ikindi kibazo, hari aho wavuze mu ambasaderi umwe ku itariki ya 15 z'ukwa kabiri 2021, umwambasaderi umwe ngo washinje Rusesabagina gukorana na FDLR, noneho uvuga ko hari n'aho bavuze ko bavuganaga ibijyanye n'intwaro nako ari mu karanire gutanga intwaro na Western Union. Ese ubwo bufasha nibwo bwonyine waramenye baba yarabahaye cyangwa hari ubundi bufasha waba waramenye? Niba ubuzi babutubwira.
So that was an accusation that my understanding from being at various meetings, I could be wrong, but I believe at the Rainbow Push fundraiser, and it may have been later than, no, it would have been maybe before that. I'm not sure of the time frame. That Ambassador Camonio had made that accusation, but it was in some public forum. I do remember that. But other than that, the other information I have would be the emails that I just read to you. And I don't know if those two are related.
Byabihagije, igisubizo kirahagije. Itariki navuze 15 z'ukwa kabiri 2010. Murakoze.
Reka tujya kuri inyandiko wakoresheje. Ni inyandiko nawe ugeze kuyivugaho. Iyo nyandiko ni yawe, watubwiye ko wayikushanyije, ni bikubiyemo n'ibyawe, hari abagufashije kuyitegura, kubera ko turaza gusaba ko munayiduha kugira ngo ije muri dossier.
Yes, I already gave it to the Prosecutor General, but yes, I have various drafts on my laptop. I worked on this for months. After I was attacked online, I stopped all contact with Rwanda. I changed my research. I moved away. And as far as I was concerned, the door was closed. I never wanted to open it again. But even though I kept everything, it took me a very long time to put this together. I had to go through everything again, remind myself of things, and it took me a very, very long time to create it. Again, I have multiple drafts of it, and I'm the one that wrote this. And yes, I would provide this to you. I believe it already has been provided, but if not, I will provide it to you.
Kubera iki umvishe ko ari ngombwa kwifashisha inyandiko uza gutanga ubuhamya?
Because for me, the way I think, I'm a writer, and I write. It's easier for me when I write to connect things and to remember things. It's one of the reasons why I use technology so much, because it helps me remember things, it helps me connect things. I'm not sure that I initially wrote this thinking that I would read it, but eventually when it got to be so long, I just wanted to be clear and precise. And I even have, this is my copy, I have all cap headings to remind me of things if I felt like I could just talk and then read the emails, which is why I said I would prefer to read it, just so I could make sure to remember everything and be very precise, because in so many ways this was simultaneous at the same time that it was linear. And it was very difficult for me to express it in a way that I felt would make sense, because so many of these realizations were occurring at the same time, but from so many different sources. So writing it is easier for me to think, and it's easier for me to express myself.
noneho turetse inyandiko tukakubaza ngo ibyo watubwira mu magambo make ku buhamya waduhaye, wabirezima gute, wabisobanura gute mu magambo make, minota 2, incamake y'ibyo watubwiye byose udafite inyandiko?
I would tell you that I met Providence Rubengisa through a conference that I facilitated in the fall of 2009. He was a keynote speaker for me. He told a story of being a genocide survivor. He told a story of being a hero, rescuing Tutsi. He told, in the conference, in the workshop, he told us about his charity stuff for the poor. He told us about fleeing into exile. I came up afterwards to thank him, and I told him how impressed I was and that I wanted to help him. We started working together on that, and I provided a tremendous amount of support for him. And again, I have those emails as well as the documents that I created for him, website. I wrote a lot, I mentioned a lot of his correspondence. I wrote conceptual things, I made contacts with people, I facilitated shoe drives. And then at some point he wanted me to write. I was hired as a ghostwriter on a couple of occasions for a few books, and he asked me if I would write his autobiography in fall of 2009, and I agreed. I interviewed him several times, and I have all the notes from that, and I can tell you it's 13 pages of detailed notes. It was through that time I could look at that document and tell you the last time that I updated or saved it. That would give me kind of a time stamp on when that was. I do recall that it was between March, April, it wasn't March, it was like April, May that I started getting suspicious. I would tell you that he introduced me to Paul RUSESABAGINA in the fall of 2009. I recall driving down to Chicago and calling my niece and telling her I felt like I was going to meet royalty. I was so excited. Then when I met with Paul, he asked me to work for Hotel Rwanda RUSESABAGINA Foundation as a volunteer, and I was so excited. It was the offices were in downtown Chicago. I went down there quite a bit, maybe once a week or so. I attended several meetings. I placed my student, who's an intern, there in January of 2010, and she worked that spring semester. Between the two of us, and of some of those correspondents, not all of them, we started talking about our suspicions at that point. It was first about the agency, questioning why it was so political. One of the things that they would do is they would call the members of this political party Team RUSESABAGINA. So we noticed that there was a lot of conflation between the two. And that just didn't seem right to us for a humanitarian organization. I would tell you that Providence gave me his password on a number of occasions, and I was in his email all the time, looking through emails, responding to emails. But at some point, I saw some things that were really disturbing to me, and they matched up with other things that I was experiencing at that time that I mentioned before. The fact that nobody was guilty of genocide, the fact that there was a double genocide, and then that, I noticed that evolved, that narrative evolved. It started off as a double genocide, But soon it became something where it was like only one genocide, and it was the Tutsis against the Hutus, not the other way around. When I asked about why it was no longer considered a double genocide, he said that people had done the numbers, academics had done the numbers, and that there were far more Hutu that were killed than Tutsi. He also said that it was the international community that came up with the guidelines for when to start counting deaths, that if you went back to 1990, there were more Hutu killed than Tutsi. I would tell you that when I saw some things that disturbed me, I started taking screenshots. I would tell you that at some point I made the difficult decision to copy. Now, I copied around 700 emails out of 10,000. I didn't have time to go through everyone. I didn't have the ability to translate everyone, so sometimes I was going by pictures, or I was going by if the subject line was in English, or if there was English in there that I could figure out. I didn't have the time to go through all 10,000. There was no way that I even came close to capturing all the emails. I just looked for the ones that I thought looked problematic. I would tell you that I thought that in the beginning I believed it, and I was supportive of them, and my emails reflect that. When I first emailed them about this Rwandan exile in Dayton, Ohio, I expressed concern about it. So I know by that time that I hadn't completely figured it out at that point. I would tell you that when my students started coming to me with concerns, that added to my concerns, very much so. And that together we started talking about it and wondering who these people really were. I would tell you that the newspaper media accounts, I remember one in particular, and I referenced it vaguely, about the showing the identity card and getting pulled out by Interhamwe. In that one specifically, he was asked to dig his own grave, and then the way he told the story afterwards, it didn't make sense to me, and I just found that so disturbing. And the reason why I wanted to mention how I am as a person, I take screenshots of everything. If I pay a bill online, I take a screenshot of it. If I'm trying to remember something, I take a screenshot of it. The reason why I have my cell phone crashed in 2012, and I lost a lot of my texts. The reason I have the text of his password is because I couldn't remember it, and I got tired of scrolling back up through all of our text, so I just took screenshots, a couple screenshots of it, so I had a picture of it. This is just kind of who I am. I'm not detail-oriented in my everyday life, but when it comes to technology, I am. And then it became very purposeful. Like I said before, at first it was curiosity. Anyone sent me an email with a long chain, I'd read it. But then it became purposeful when I started suspecting it. I was very familiar with the genocide. I read Machete Season. I read Shake Hands with the Devil. I know what happened. And when I had this realization of who they were, I couldn't believe that I was right in the middle of it. In fact, I remember thinking, could it be possible that I figured this out? And I didn't understand why others hadn't. Because even though I went to a lot of work to connect the dots, it wasn't that hard. And I didn't understand why other people weren't figuring out the conflicting narratives. But there's a difference between, and I do think some people had, I really do, because you could see in the emails where people would just stop working with them and kind of go away. So I do think Americans were figuring it out after a while. I found it at some point that there were several Americans that had worked on his charity to help him before, and they just kind of disappeared. So I think that was happening, and I could have done that too. I know I could have, and my life would have been much easier had I done that. And I don't know what else to say other than that, other than
Okay, murakoze cyane. Ubu muryango Fondation Rusesabagina wayikoreye igihe kingana iki?
So I met with Paul. I was trying to figure it out. I think it was October of 2009, and I know he had me meet with the foundation right after that. But I think I officially started working with them around, it must have been like December of 2009. I faded away after I started distancing myself after when my student finished. And then I wasn't involved at all, except they did invite me to that one meeting, and I attended. But other than that, I had distanced myself from them. But I never told them what I knew.
wabisohotsemo ryari?
Oh, I think after that September 15th meeting, I don't think I had contact with them again after that. And it was easy because I lived in the suburbs. It was an hour drive, and I was very busy. So it was kind of a natural phasing out.
Urakoze. Ikindi kibazo, uretse ibyo waganiraga na Rubingisa, wowe wigeze uganira na Rusesabagina ku birebana n'imikorere ya PDR, imikorere ya FDR n'imikorere ya RNC?
Did I talk with him?
Wowe ubwawe?
No, I did not.
Hari imeri ye ya Rusesabagina waba warabonye ivuga ku mikoranire ya PDR na ku mikoranire ya PDR cyangwa se mu fondation ye na FDR na RNC, imeri yanditswe na Rusesabagina?
So I can't say with certainty because I have not translated all of the emails. There are a lot of emails I never translated. Kinyarwanda or Swahili is only good so far, so no, I don't know, to tell you the truth. There may be emails. He wasn't active in terms of having a lot of conversations online. Like I said, he was a recipient in most of them. And there are times where he would, again, share information and say, let's discuss, or for your information.
Murakoze. Hari amafaranga ngira ngo amadolari 60 bigeze kutubwira ngo fondasiyo ya Rusesabagina yahaye umuryango wa Rubangisa. Yadusobanurira neza, ntabwo byari byumvikanye neza.
I don't really know more than that, other than there are emails where there's a contract that I believe in the emails that shows the 60,000. The American leader of GFR, there was an email that he wrote to Providence saying, can you please ask Paul if we can use this for salaries? After they were shut down, there were emails about how they were, Global Family Rescue was going to transition to Uganda, and I believe they did. And that's all I know. They did give it. I believe they gave the grant.
Ibirebana kuba Rusesabagina yarabonanye na Murwanashyaka, wabikubwiye ni Rubangisa cyangwa wabikuye muri za email?
Both. It's in the emails that I read, and then also when I met with Providence Rubangisa on June 4th, 2012, when I was working with U.S. law enforcement, he referenced it as well.
Naho ibirebana na za ntwara watubwiye zo muri Afrika y'Epfo, nabyo niwe wabikubwiye cyangwa nizo email ze wasomye?
Providence Rubangisa told me. That's when he said that Paul had messed it up. What he said is that, I can't pronounce his last name, I'm sorry, that he was supposed to meet at Paul's hotel, and that he instead wanted Paul to meet at his house, and Paul didn't want to. So the meeting didn't happen. Instead, what Paul did, I think in the emails it references earlier meetings between the two of them. But in terms of that one meeting that Providence had referenced, and that is also referenced in the email. Providence told me that was when he said Paul blew it, and that Paul had just given him Jerome's contact information and said that they could meet in a big meeting in Brussels in a few weeks.
umutangabuhamya wakoze cyane turagushimira nkeretse nimba hari ufite akandi kabazo ko kubaza umutangabuhamya nawe ubundi ngira ngo twasoreza tunabasaba tubabarire twatinze cyane ariko muri ubona ko byari ngombwa abandi baburanye hari ufite akabazo ka precision kandi akabazo yashaka kubaza umutangabuhamya cyangwa ubushinjacyaha ariko nimba ntawe twasoreza ngo turabona ntawe katwongere dushimire umutangabuhamya wakoze uretse kugenda uraza kudusinyira inyandiko mvugo noneho umwanditsi araza gusohora inyandiko mvugo tuyisinye ariko mbere yuko dusoza turagira ngo tuvugane twashaka gushyira iburanisha kuri 31 azaba ari kuwa nimba ntibesha azaba ari kuwa gatatu yaba yicariye umutangabuhamya yaba yicariye araza gusinya baramusinyisha azaba yicaye hari ikibazo dushize kuri 31 ngira ngo kubishinjacyaha nta kibazo mwavuze mu gitondo ko iminsi yose muhari ahubwo abandi baburanye abavuka cyane cyane nibo bakunze kugira ibibazo ariko nabo ndabona ntawe ufite impungenge hari uwazamuye ubwo ndi kuvuga kuri audience ya 31 yejiho twabivuganye turaza kwimuriraho urubanza turi kuvuga kuri 31 kugira ngo turebe ko twakomeza ejo no kuri 31 tukazakomeza wimetra ngira ngo ahari nshobora kuba ntasobanuye neza impamvu kubera ko twarebye gahunda yo mu kwezi kwa kane asa nkaho mu cyumweru cya mbere cyose nta bitakunda rero idakunze ya 31 ngira ngo byaba bigiye kujya mu cyumweru cya kabiri cy'ukwa kane niyo mpamvu twashaka gushyira iburanisha kuri 31 w'imetre
murakoze nyakubahwa perezida ku ijambo nagira ngo munsaba urukiko kuko n'ubundi numvise uko ababuranyi bakurikirana abo nunganira bashaka kutagirwaho kuri iyo tariki 31 ubwo mfite
I am afraid that we had agreed that whoever will have a challenge, they will inform the court. So, but if it's an individual challenge, we can be informed. Thank you very much. If anyone has a challenge, you can inform us and your case will be heard later. Do we have any other challenge or any comment? We work tomorrow or we wait till April if it's a general concern? Thank you very much. There is a document that the witness hadn't elaborated on, but we had said that we will introduce them. All the information given here, we had said that this information, Rubingisa had been interviewed on this by the justice system in Belgium, but we had said this in the beginning. So this is what we're thinking about. Was it captured? This wasn't for the discussion on this witness testimony, but we wanted that to be clear, and I think it was clear at first. Thank you, Your Honor and honorable judges. I would like to propose to the court that for us to use well our time, if the court can allow us to meet at once, that was decided. That was decided. We'll stop at 12, have a lunch break for 1 hour, and then start from 1 to 3. I was saying this, Your Honor, because the pause of lunch is not easy because someone may not even go for lunch. But if we can go until, the hearing can go until 2:30 and then close, then no, I don't think that's possible because it's not easy. We have prisoners here who might need to take lunch. But this is not set in stone. If we want to revisit this, we can always revisit this. Attorney Mugabo, this is just a proposal. We agreed this in the morning. We don't want to come back to this, but when we see that it's fitting that we come back to this following the proceeding of the case, we'll always come back to it. This is not set in stone. This can always be revised. The next hearing is tomorrow. You know the program that we have. The registrar is going to give us the minutes for our signing. You bear with us, we had to take time. Today was not a regular day. We had so much to cover today, so we took time. Claude should help you, Boniface, so that we quickly sum this up. One can have the others sign if we don't have it on the same page, if you don't have the names on the same page. We're calling all the attorneys to come for signing.
Claude, umwe yabasinyisha abagororwa n'abashinjacyaha undi ahamagara gusa birihuta.
Matakamba Jean Kimasi. Matakamba Jean Kimasi.
Claude, wabwiye ukabasinyisha hariya undi akabahamagara.
Can we have all the attorneys sign and all the defendants, please?
Yeah, bonita. Yes, Yumva company. Register the
Karam. Boniface sinyisha amatangabuhamya n'abo basemuzi basinyisha.
Jean-Claude Mugenzi
banza usinyisha uwo musemuzi
nibo mpamagara none. Karegesa Fenias Rudahunga ashwe ntaho hari. Ntaho hari hagarariwe nabo bavuga cyangwa ntaho hari.
Koze cyane iburanisha ry'uyu munsi rirashojwe.